Give me a shirt. It's yours.
All right. Calling case number 2334-6578, Larry Mason versus CR436. Please state your name for the record.
Larry Mason.
Thank you. Is CR436 here? Mr. Mason, is this a dismissal?
It's a conditional dismissal, Your Honor.
Is Ms. Toller present?
She informed me she would not be present.
All right, do you have her, did she sign the conditional dismissal?
She did, Your Honor.
Okay, all right. Ms. Toller is not present, but the conditional dismissal is signed. What are the terms?
She has until June 15th to be compliant with her lease and be at a zero balance.
All right, what's her balance right now?
Sorry, Your Honor.
What is her current balance?
Her current balance is $2,350.
And this 4B check?
Yes, Your Honor.
You said she did sign it already?
Yes, sir.
All right. Okay, the court is satisfied. Have you submitted it to us yet?
Bringing it in today, Your Honor.
Okay, all right. Well, the court is satisfied. The parties have already signed it. Please submit it like you said you will, and the court will sign it. If you bring it in person, we'll get it back to you today.
Thank you, Your Honor.
You're welcome. What other two matters did you have ready?
All right, the next one, the last three is 582.
Calling case number 2334-6582. This is Larry Mason versus Paula Langford. Can you state your name for the record again, Mr. Mason?
Larry Mason.
Thank you. And you are the plaintiff. This is a complaint to recover possession of property. Mr. Mason, do you have a conditional dismissal on this one?
Yes, Your Honor.
All right. And has Ms. Langford reviewed it and signed it?
Yes, Your Honor.
All right. What are the terms of this conditional dismissal?
The terms are that she is going to be compliant and at a zero balance by June 15th.
By June 15th. All right. And what is the balance right now?
4,100.
Okay. And it's 4B check.
Yes, Your Honor.
What does it mean to be compliant?
To be compliant means to be at a zero balance and not to be in to have any rearage.
Okay. All right. All right. The court is satisfied with the conditional the terms of the conditional dismissal set on the record. Both parties have signed it. Please bring it into the court so we can put our signature on it.
Thank you, Your Honor.
All right. No problem. You're welcome. What's your last one? 583?
Nope. I don't have the number on this one, but it's Richard Lawrence, and it's going to be an outright dismissal.
583. Calling case number 2334-6583. Larry Mason versus Richard Lawrence and all occupants. Please state your name for the record.
Larry Mason.
Mason. And are you requesting that this case is dismissed without prejudice?
Yes, Your Honor. Sorry, I didn't hear you, sir.
This matter is dismissed without prejudice.
Thank you, Your Honor. That's the only three I had that have resolutions. The rest are I'm seeking judgment. So I appreciate that, Your Honor.
Let's see. All right, is Alexis Vaughn here?
Yeah.
All right, have you spoke to Ms. Snyder? Are you here for Wassery's office?
I am. It won't let me change my name. I apologize, Your Honor.
I'll give post privilege to you can
Thank you.
no problem. Alexis Vaughn is here. No.
Good
I'm
morning,
sorry.
Your Honor. This is Phyllis Wood. I represent Miss Vaughn. I need to speak to her in a breakout room. Mr. Woodrow is the plaintiff's counsel in this matter. He's also waiting in a breakout room. We're attempting to resolve this matter.
You get back to room 7, or do you need to speak to?
I've
You
tried to put Miss Vaughn in room 8. She still has not joined.
Oh, I tried to join, but I was the only one in there. I didn't know if I was in the wrong one.
So let's see. Let's move. I'll move you to room 9 so you get a fresh invite, and I'll invite you to room 9.
Okay.
Thank you, Your Honor.
Well,
Your Honor, I'm happy to say that Ms. Rayner and I have come to an agreement we need to put on the record when you get to it.
let's get to it right now.
Okay, thank you very much.
Calling case number 233455507. This is Gary Sellers versus Margaret Rayner and Summer Daycare Early Learning.
Good morning, Your Honor. For the record, Ron French appearing on behalf of Mr. Sellers.
Thank you. And Ms. Rayner, can you state your name for the record?
Margaret Rayner.
Thank you, Ms. Rayner. Good morning.
Good morning, Your Honor.
I was informed by counsel that you all reached a resolution.
Yes, sir.
All right, can we place these terms on the record, counsel?
Yes, Your Honor. Your Honor, it's my understanding that Ms. Rayner has agreed with my client, Mr. Sellers, to make $900 payments monthly, the first one within the first week. She agrees, and my client agrees, that the balance is $10,000 that's outstanding. She's going to make that first payment of $900 within a week from today, and then she's going to make monthly payments on the 22nd of every month until this $10,000 is paid off. We're going to enter a conditional dismissal with those terms to get rid of this case once the balance is paid in full.
Okay, so what's the current arrearage? $10,000?
$10,000, Your Honor.
And that is including May's rent?
Yes, I believe so, yes.
I've been out since the end of March.
Oh, yeah, there's no possession right now, Your Honor. I'm sorry. That is right. That is correct.
Okay, all right. Thank you for clarifying that. So there's no ongoing payment. This is just a $900 a month payment plan to basically dismiss this case, and no money judgment, no judgment in your name, Ms. Rayner, and
Right.
case.
Okay.
Okay, all right. So
Your Honor,
it's 4B. Go ahead.
Where do you want us to send the conditional dismissal with these terms?
Could you fax it to the court, or?
Yes. What's the fax number, please?
I have it on my card up here. Please give me 1 second.
Okay.
Haven't quite committed it to memory. And we'll be back in person on the 5th, FYI.
Oh,
So-
no.
So I've even allowed for emails, but when you send it through an email, sometimes I like for it to hit the second floor. So everything is uniform with what's been being input. So
Okay,
I tried, but I think it's best to just stick to the process for another month. You got a message?
yeah,
It's 313
yep,
965
I'm sorry.
3551.
One more time, please.
313 965 3951.
Okay, Your Honor, we will get that in by the close of business. Hopefully.
All right.
Thank
All
you.
right. It'll take a day or two to get to us, and then we'll sign it, and then it'll be in the system today, though.
Thank you
So
very much, Your Honor.
you're welcome. It's 4B check.
I believe, yes.
Well, yeah, and then it's not a possessory issue, so it's really the judgment entered if the payments are made, but if the payments are made, this case is dismissed. So,
Right. It's moved.
okay, good luck, Ms. Rader.
Thank you.
Please send that in. You're welcome.
Thank you, Your Honor.
You're welcome.
Sit back on it. Air it out, so. Sit back on it. Keep it there.
No, I'm leaning with it.
No, I forget up in there. It's all in there. Sit right back on. I keep my pants and drinks.
Manageable chores are.
Cool me. How about you? You just did that. Man. I pulled down. Let it out. How about you?
No, the underwear had it rough.
How about you? Hell, soon as they went on A.
Excuse me, sir, what's your name for court? I'm with your device. The young man are you laying on the couch? What's your name for court? Unmute your device, sir.
Hello?
Good morning, what's your name for court?
My name is, I'm filling in for Corey Schwartz.
What's the case number?
Case number.
233
233
46
46
572.
572.
576. It says Alicia Coleman and occupants.
Yeah.
And what's your name?
D'Angelo Mallory.
Okay, you can place your device on mute. The court will be with you shortly.
Okay, thank you.
Attorney Snyder, Mr. Dexter McElrath is present in the courtroom.
Okay.
So, is there a resolution on his case, or do you all need to have a discussion?
We need to have a discussion.
Okay, Mr. McElrath, do you have a cell phone? Do you have a cellular phone?
Yeah, but I left it in the car.
Okay, we'll figure it out. I just wanted to let you know, he's here. I might give him a phone to, please message me your contact, and I'll have him call you.
Okay.
If that's what you want to do. That's how you want to go about it, but,
That's fine. Give me 1 second.
all right. Attorney James Murray, good morning.
Morning, Your Honor. Hope all is well.
Something on your wall.
One more time.
Nothing. What's up? Do you have Mr. Murray this morning?
Yes, I do. Case ending in second. Case ending in 5397.
All right, you ready for it to be called?
Correct, Your Honor.
Calling case number 2334-5397. This is Sherry D. Anderson versus Darius and Asia Clark.
Good morning again, Your Honor. James Murray, PA 5490, appearing on behalf of the plaintiff.
Good morning, Mr. Murray. Is Darius Clark here or Asia Clark here?
I'm here, Darius Clark.
All right. Good morning, Mr. Clark. Do you all have a resolution?
No, we do not have a resolution. Today was actually the day and time for my motion for alternate service to be heard. Considering that the defendant is present at this time, I would like to move forward and respectfully request the court sign my motion, and then we can work out a resolution at the next hearing.
And did you submit that book out? Mr. Clark, can you stay record?
The phone is breaking up. I can't hear you.
Can you state your name? Can you say your name for the record, for the court record?
Darius Clark.
Okay, do you reside at 18494 Ashton?
Correct.
All right, there's a lawsuit, there's a summons and complaint that was filed for non-payment of rent. You're here for that matter. However, that matter had a money judgment attached to it. Money judgments require personal service. The court officer, Stephen Mason, has been unable to serve you. Therefore, Mr. Murray, the attorney for the landlord, has motioned the court for alternate service, which will allow him to tag it on your door because he cannot, after diligent attempts, successfully serve you. Although you're here, I'm going to grant the motion for alternate service. But while you all are here, if you want to speak, I can put you in a breakout room. So today's your motion for alternate service. Alternate service is granted. You can use means of alternate service to serve Mr. Clark. But since you all are here, if you have time, just have a conversation and maybe you all have a resolution or come back with the resolution like you said, Attorney. So
I agree, Your Honor. Please be placed in the breakout room.
sure, but motion for alternate service is granted.
Thank you, Your Honor.
You're welcome. So, Mr. Clark, I'm going to invite you into a breakout room. You're on the phone, so you're going to automatically go in there, and then Attorney Murray will follow behind you. All right.
Okay.
All right.
Thank
Room 11, council. Ms. Watkins, good morning.
Hello?
Yep, yes, good morning.
Good morning.
Good morning. Hold on.
This
So
is yeah.
this case was,
Park. Your phone breaking up. I'm sorry, sir.
hold on 1 second, ma'am. Attorney Berry,
Yes, Your Honor.
today was the date and time set for a hearing, correct?
Correct.
Okay, so we need to adjourn this hearing and get another date. I've granted the motion for alternate service while both of you all are here. Let's get another date to come back. How much time do you need?
A week, 2 weeks maximum.
All right, let's, May 30th or May 31st?
I check my calendar.
May
May
30th is Wednesday. Memorial Day is Monday. The 30th is Tuesday. 31st is Wednesday.
May 30th is fine.
Okay. Mr. Clark,
you. Yes.
we'll be back in court May 30th at 9 a.m.
30th and 9. Okay.
All right. All right. I'll invite you all back to a breakout room.
Okay, thank you.
You all are free to leave. You all don't have to talk to me anymore. You can leave after you finish talking.
Okay.
Go to room 10. All right, Ms. Watkins, you had your hand up. What's going on? How can we help you? You're muted.
Wondering why he mentioned my name. I was here for Larry Mason. He trying to evict me, and I had a date today to be here.
Yes, you're checked in, Victoria Watkins. Do you have an attorney, Ms. Watkins?
No, Your Honor.
Do you want an attorney?
No.
Are you sure?
I'm at work right now. I was just making sure.
No, I mean, you're here, he's checked in, you're checked in.
Okay.
And so it's just up, do you need representation? If not, then I can put you in a breakout room, Mr. Mason. If you want representation, I can put you in the breakout room with an attorney.
No, I'm okay, Your Honor.
Okay. All right, Mr. Mason,
Yes, Your Honor.
I'm going to invite you to a breakout room with Ms. Watkins. If you all are able to work something out, let me know. Regardless, we have to call the case, but I'll call the resolution earlier because in about 5 minutes, I'll have some cases to call. So just let me know what happens and I'll recall it. Well, I'll call it initially. Room 4, Ms. Watkins, I'm going to remove your hand. Join that breakout room on 4. Yeah, there you go. So some of you all haven't heard your names called. But if you're here, you will be checked in. Just make sure that you're in the right courtroom. Attorney Wyrock, I'll give you some breakout privileges. If parties are ready, raise your hand so you're in the queue. And I just go in order of whose hand is ready. If you're ready. If you're not ready, don't raise your hand. Mr. Tanae Davis, good morning. Ms. Davis, good morning. Audio issue. And Latasha Lopez.
Yes, hi.
Hello. You have your hand up? What's going
Yeah, I'm ready.
on? Okay. Did you speak? Okay. Did you speak to Attorney Horka?
I spoke with a attorney. I don't know what her name is. I think it was legal aid. I'm sorry.
Okay, who's your attorney?
I don't know. I'm not sure.
Are
I
you
spoke with
represent?
somebody. I went in the breakout room earlier. Huh?
Yeah, did they say they will represent you?
No, they told me to talk to the attorney that's here for the landlord.
Okay.
Your Honor, Ms. Lopez was advice only. We advised you to speak with Attorney Forca to see about a payment plan.
Okay. Is Mr. Horka here?
I'm here, Judge. Good morning.
Good morning. Every time I ask that, you just pop up.
Can't get rid of me.
But I appreciate. Let's see. Do you have breakout privileges? I will give to you. And I think Ms. Lopez, I'll invite Ms. Lopez into room 8.
Thank you, Your Honor.
You're welcome. And Mr. Nate Davis, do you want an attorney? Do you want counsel?
Yes.
Are you on a phone and a device?
Just the phone.
Are you Mr. Nate Davis?
Yes.
Okay, because I see a picture up there. Hand up.
I was supposed to be on at 8:30, but I'm not sure.
No, I just see two devices. I see two Tanae Davises.
Yes.
So why are there two Tanae Davis?
No, it's only one. I don't know why you see two, or I don't know.
Okay. I'll invite you to Attorney Horka is the landlord on your case. So he's in the breakout room now. Let's see if I can raise your hand. Let's see. I'll invite him. You're on the phone, so you can't see the breakout room. But I'll highlight you and have you checked in. So when Mr. Horka is back out, I'll let him know you're here.
Okay.
All right, Brandon's iPhone.
Good morning, Your Honor.
Good morning. Is it Brandon?
Yes, sir.
Is it Brandon Thomas?
Yes, sir.
All right. Mr. Thomas, do you have an attorney?
No, I don't.
Or are you requesting counsel, or would you like to speak to the landlord's attorney?
I would like to speak to the landlord's attorney.
Okay. So this is what I'll do. All right. I'm going to invite you and Ms. Davis in a room. And then When Mr. Horka comes back, I'll ask him to go to that room. So you all will be in the room together until he pulls one out and talks to one, and then that way it should work a little faster. So you won't be in the main session. You'll be in a breakout room. So you won't hear anything, but once he's done and ready, he'll get to you. So
Okay, thank you.
you're welcome. Brandon Thomas, room 11. Room 11. And Ms. Davis, room 11.
Yes. Hi. What you say?
I just sent someone else to room 11. Excuse me. Oops.
Do you want me to hang up the phone and then log into the Zoom regularly where I can see?
No, you're all right. Just know you're in a breakout room right now. I'm about to send you to a breakout room, okay?
Okay.
And send Attorney Horka to the breakout room to get you and talk to you separately, and then we'll call your case. So you're all right.
Okay.
Attorney Snyder. Yeah, Attorney Snyder.
Yes, I have a resolution with Ms. Hart.
Okay.
Case numbers ending in 606.
I just noticed you put the number in. I don't have two screens, so I didn't see the chat. You said 626?
606, 606.
606 with Natasha Hart?
Yes.
All right, calling case number 23346606, Elite Housing Professionals versus Natasha Hart.
Thank you, Your Honor. Jackie Snyder Powder on behalf of Mark Wasbury, 82554 is my P number. We represent Elite Housing Professionals in this matter, and Ms. Hart is present in the courtroom.
All right, good morning, Ms. Hart.
Ms. Hart, unmute your device and state your name, please.
Good morning, Natasha Hart.
Good morning. All right, were parties able to work out a resolution?
We were, Your Honor. This is just a termination of tenancy, and Ms. Hart indicated that she is able to move by June 6th.
All right. This is a termination of tenancy where Ms. Hart, you agree? Well, are we entering this as a consent judgment?
Yes, Your Honor.
All right.
We're going to change it to all occupants for her.
Okay, so we'll do it as a judgment by hearing.
Yes,
for
Your
all
Honor.
occupants must vacate by, could you give me that date again? June
6th.
June 6th, 2023. And after that day, a writ of eviction can be filed against all occupants. So your name is removed as the named party, and a judgment will go into as all occupants. It'll go into the system as all occupants, where all occupants must vacate by June 6th or a writ will issue. All right, Ms. Hart, do you understand what's going on?
Yes, sir, I do.
All right, good luck, Ms. Hart. That concludes your matter. You are free to vacate. You are free to leave today. Keep an eye. You're welcome.
Have a good night. Yes. Bye-bye.
Where Attorney Snyder,
Yes, Your Honor.
when the defendant comes back in, I'll have him call you. It'll be from I think it's a 248 number.
Okay.
Attorney Horka.
I have a resolution on the case ending in 617.
I'm sorry, Attorney Woodrow, I'll get to you. You were actually next, but since I called it, is this Latasha Lopez, Mr. Horka?
Yes, it is.
All right, yeah. Calling case number 2334-6617. This is Sweet Living Inc. versus Latasha Lopez.
Morning, Joe Horka, P75969, appearing for the plaintiff.
Thank you. Ms. Lopez, can you state your name for the record?
Latasha Lopez.
Thank you, Ms. Lopez. Mr. Horka, would you like to put the terms on the record?
Yes, please, Your Honor. This is a non-payment of rent case for possession as well as a money judgment. Total amount due, including the court costs, is $1,630. We'd like to enter into a consent judgment for that same figure with the following payment installments: $1,000 by May 22nd, and the remaining balance by June 12th.
The remaining balance by June 12th. And what is the monthly rent?
Monthly rent is $650 per month.
$650 per month. So in June, $650 plus $630, right?
She's only going to pay through the month of May by June 12th.
Could you repeat that one more time?
This second installment payment of the additional $630 will only get her caught up through the month of May. So she will have to figure out something else for the June rent.
Okay, so it'll be $630, but the $650 is already it's also owed.
It will be owed, but not contained within this particular settlement.
Okay. I just wanted to be clear on that. So she's clear on it. So Ms. Lopez, $1,630 in two installments, $1,000 by May 22nd and $630 by June 12th. But you still have to pay your $650 monthly in rent. Are you all in agreement of those terms?
Yes, I'm fine with that.
Okay, and there was personal service in the file. Defendant paid for a money judgment. This is a money judgment, so I'll state that for the record as well. But
And I do actually stand corrected. I don't believe this was actually a money judgment.
there is no money judgment. $1,630 by June 12th in two installments. Do you give Mr. Horka consent, permission to sign your name on the judgment?
Yes.
All right, court is satisfied. Good luck, Ms. Lopez.
Thank you.
Mr. Horka, you're welcome.
Yes.
Mr. Horka, you have two people in room 11 who want to speak to you.
Thank you.
631. They both are waiting. I'll let you deal with it however you want to deal with it, but they're there. Attorney Woodrow.
Yes, Your Honor, we have a resolution on case ending in 540.
Calling case number 2334-6540. This is Day by Day Property Management versus Alexis Vaughn.
Good morning, Your Honor. Hugh Woodrow, appearing on behalf of the plaintiff, Day by Day Property Management.
Thank you.
Your Honor, Phyllis Wood, P 74800 on behalf of Ms. Vaughn. Oh, Your Honor, you've lost sound.
Good morning. Good morning, parties. All right, and Ms. Vaughn, can you state your name for the record? Ms. Vaughn?
Alexis Vaughn.
Thank you. Were parties able to work out a resolution?
We were, Your Honor. We've agreed on a conditional dismissal with a move-out date of June 16th.
All right, this is a conditional dismissal. Complaint to recover possession of property, so there's no monetary amount. Did you say June 16th?
Correct.
All right. So Ms. Vaughn, this matter will be dismissed if all parties vacate by June 16th. In the event parties do not vacate by June 16th, is 4B checked, counsel?
Yes, Your Honor.
4B is checked, which means that a judgment and a writ of eviction can be filed at the same time. You understand?
Okay.
So, and is there someone she's supposed to return the keys to?
She can return to the rental office on site, Your Honor.
Okay, is that a problem, Ms. Vaughn?
Nope.
All right, well, I'll enter this conditional dismissal with the move out for June 16th, and good luck, Ms. Vaughn. Thank you, Cardi.
Thank you.
Thank you, Your Honor. Phyllis, are you going to draft that up?
I just sent it over to you. You should have it in your
Oh.
email.
Okay, thanks.
You're welcome. Bye. Thank you, Your Honor.
Thanks.
All right, Mr. Horka. And then Attorney Wyra.
Good morning, Your Honor.
Good morning.
I was in another courtroom. Has anybody appeared on my 830 case for 6601?
Wayne Grave, is Wayne Grave here? Is Wayne Grave? Is Wayne? I don't believe. See it. Yes, but I calling case number 2-334-6601 3434 Russell 32 LLC versus Wayne Gray II.
Good morning, Your Honor. Diane Wyrock on behalf of plaintiff P59773. This is a non-payment on a commercial property.
All right, thank you. Does anyone reside at 3434 Russell? All right. Counsel?
I'm requesting a default judgment. There is presently owing $15,585 together with $160 in court costs and statutory attorney fees for a total of $15,745.
That's 15745?
Yes, Your Honor.
Okay. Wanted to make sure it wasn't 50745. All right,
What would be your move out date?
one sec. Is Wayne Grave here? Our default judgment is granted. The move out date will be May 26th.
Pardon me?
May 26th.
Okay. Thank you very much, Your Honor.
You're welcome. So default judgment is granted. Defendant must pay 15,745 by May 26th or a written issue. You're welcome.
Thank
Attorney
you.
Wara.
Excuse me, Judge, I have Attorney Hoot on the line, and he wants to speak with you about an adjournment date from Judge Kennedy. I guess they're telling the attorneys to call us if adjournment or something. I still if the case is down to the balance.
Great. Thank you. We appreciate it. Is there any Lakeshore legal aid that can assist Mr. McElrath? Is there any Lakeshore legal aid in the building? Or
I'm available, Your Honor.
yeah, we have a defendant in 36 District Court.
Oh, I'm not in the building, Your Honor. I apologize.
Yeah. Is there a number he can contact you all? I'll put it in the chat. Thank you. Attorney Snyder.
Yes, Your Honor. I just spoke with Mr. McElrath on the phone. And he indicated that he doesn't have a move out date, which is what we were looking for, and that he hasn't spoken with an attorney. So I'm assuming at this point, Your Honor wants him to speak with an attorney.
Okay.
All right, Lakeshore Legal, can you provide a telephone number where you can call? Is that your only, do you have any other cases this morning? You have more?
I have two others for Shirley Hawkins versus Vanessa Reed and Vincent. The other case is Vincent Chambers. The last 445 and 546. I believe those are both defaults, as neither party has appeared from what I've seen. And then that's my 4.
So I prefer not to adjourn this if we can get it done.
Hello?
I agree, Your Honor.
Yes, Vincent Chambers is here.
Okay. You hadn't checked in, so I'll grab you and we'll go into a breakout room, Mr. Chambers.
Yes, my apologies. I had a hard time finding you guys. My apologies. Vanessa Reed is also here.
Okay. I will talk with them, Your Honor.
My apologies.
See.
So I guess
Ms. Evans, I sent you an invitation to join Breakout Room 6. Would you please join? We can talk.
Attorney Spaniolo here. Good morning, counsel.
Good morning, Your Honor. I am.
All right, is anyone here from 1091 Blackberry?
Your Honor, I did see what appeared to be someone from 10917 Roxbury. Her name would be Kimberly McAfee.
Kimberly McAfee. Ms. McAfee. Ms. McAfee.
Your Honor, she may be in a breakout room. I reached out to Megan.
Yeah, right now.
Oh, okay, sorry.
Can't figure out.
Good morning, Your Honor. This is the McAfee case. Is that right?
Yeah, yes.
Okay, I have been speaking with her. She's not an occupant of the property. However, she does have a deed to the property herself. I'm not representing Ms. McAfee. I was hoping that her uncle, who is the occupant, would be able to appear today, but it sounds like he's maybe having some technical difficulties. That's Mr. Pickett. Mr. Pickett here? Doesn't sound like he is. I'm happy to talk to him and see if, we might be able to represent Mr. Pickett. I'm not sure what's going on with the ownership issue.
I'm going to still send this out.
Perhaps Mr. Spaniolo could.
Yes, I'd be more than happy to share some or give some context to the court. I don't know if you want to put it on the record, Judge, or just for me to share with you what I've discovered.
I'm gonna talk to nobody kissing this phone. Who is that?
All right, so would you all like to go in a breakout room and try to figure this?
Certainly, we can go into a breakout room if you want.
The issue is I'm not representing Ms. McAfee. And
Right.
she's not a defendant here because she's not an occupant. As I said, we were trying to get the occupant here, but he seems to be having some issues. But if Mr. Spaniolo could just, I guess,
So,
explain his client's claim to ownership on the record.
Well, my client, I provided the court filed and served the pot.
Attorney Brown, if you don't have a defendant to represent, how are you representing the defendant and requiring Mr. Spaniolo to put his ownership proof on the record? How is he even obligated to do anything?
Well, you're right, Your Honor. I don't have a client here per se. I mean, the court rules do require him to obviously prove standing and that his client has ownership. I just,
argue on this case.
I'm not arguing, Your Honor. I'm trying to help the court hopefully reach a resolution here. I'd like to speak with the occupant, potentially represent him, but Ms. McAfee could probably provide the court with some information as well. I guess you could say.
Mr. Brown, I'm going to put you in a breakout room, Mr. Spaniolo, and you all can work it out. But I just wanted to state on the record that he's technically not obligated, but in the interest of working it out and the interest of getting this docket done, you do this for everybody else, so it really doesn't make too much of a difference.
I certainly have no objection, Judge.
That's fine.
You say you don't. Okay, great. So it's not an issue, Attorney Brown. I just had to state that.
Mr. Brown, can you please put me in a breakout room?
Yep, will do.
Thank you.
All right, thank you all.
Good morning. Hello?
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 Good morning.
Good morning.
Good morning. Have case 2334658 been called? I've been on this line since 8:40.
Oh, I don't know.
Yeah, we all been in the waiting room, so we're just waiting at this moment.
Okay.
Yes. Oh, this is the waiting room? Oh, this is not where the judge is? No. Oh.
This is the judge. I'm the judge. This is not the waiting room. In case of courtroom right now. I need some clarification. Good morning, Mr. Clark.
Order.
All right, Mr. Mason. Let's see. Mr. Mason, do you have a few cases that are ready?
Yes, Your Honor. I have Victoria Watkins, who's been waiting patiently here with us, and then I have two that have not shown, so I would seek a default judgment.
Pardon me, Your Honor. I'd like to check in on one of Mr. Mason's cases that I filed an appearance in.
Okay. Which one of those cases?
It ends in 6581.
6581 with Heather Burke. All right, I have you checked in with that case. And you said Victoria Watson is ready to go?
Yes, Your Honor.
All right, we'll call Victoria Watkins, and then Attorney Wood is here for 581. On case number 23346580, Larry Mason versus Victoria Watkins and all occupants. State your name for the record, Mr. Mason.
Writing them now.
Larry Mason, Your Honor.
Thank you, Mr. Mason. Ms. Watkins. Ms. Watkins, are you here? Victoria Watkins. Mr. Mason, did you see Ms. Hawkinson?
Yeah, you put us in a breakout room about an hour ago. She was at work though, Your Honor, so she might have had to leave. I don't know.
Oh, she had a nursing uniform on?
Yes, Your Honor.
All right. What agreement did you all have worked out?
No agreement. She was unwilling to accept my offer, Your Honor.
Okay. All right. So we'll have a hearing. I'll recall this. Attorney Wood has a matter with you. Maybe you all can work that out, and I can call that in the meantime.
Okay.
So, Attorney Wood, you have breakout. So can you just breakout room? And
Sure.
I'll keep pulling some cases.
Yes,
Mr.
Your Honor.
McElroy, is there any way? All right, we have an in-person defendant who needs legal counsel. Is there any way they can? What? I don't know a number. Let's see. There's no number that's being provided. So, Mr. McElroy, let's give it a second, and we'll try to figure out how to get you a legal aid. We may have to go in there over there in person. I don't know how else it will work. Is Vanessa Reed here?
I believe she's in a breakout room, Your Honor.
Okay. Vincent Chambers, are you ready, Mr. Chambers? Or
Same thing, Your Honor. I spoke with both of them and they wanted to speak with attorneys.
Okay. Is Frankie Latancourt here? Yeah. Is Latanya Evans here? All right, is Philip Henderson here? Philip Henderson.
Latanya Evans is here.
All right, Latanya Evans. Is Veronica Walls here?
Yes, Veronica Walls is here.
All right, have you all spoke?
No.
No.
Do you all have a resolution?
No.
All right. Ms. Evans, do you have an attorney?
Yes.
Who's your attorney?
Connors.
Okay. Mr. Brown?
Yes.
All right. I'll call your case once have you spoke to your attorney?
Yes, I have.
Okay. And Mr. Brown?
Tony Davis is still here, but I'm just waiting.
Thank you, Ms. Davis. Sterling, is Candace Bailey here? Candace Bailey? Oh.
Yes.
Oh, he hung up, Judge. Oh, shit. My bad. Is Candace Bailey here?
Yes.
Did you speak to attorney, did you speak to Sterling Watson?
No.
All right, you all need to speak. Do you have an attorney, Candace Bailey?
Legal aid.
What is your attorney's name from legal aid?
I don't know his name.
Your Honor, this is Megan Huff, law clerk.
Martinez.
Yep, James Martinez.
Martinez.
All right, has Mr. Martinez talked to Sterling Watson? This seems to be the next step. Mr. Horka.
Got two ready for you, Your Honor. First one ending in 631.
Calling case number 2334-6631, Investors Property Management versus Kimo Neal and Tanae Davis.
Morning, Joe Herca, P75969, appearing for the plaintiff.
And Ms. Davis, can you state your name for the record?
Any chance she's in the waiting room, Judge? She had to hang up and call back in after our breakout room.
Let's see.
Actually, see a Tanae Davis in the gallery.
I see it tonight, Davis. Ms. Davis.
Want to let them know what happened?
Where the last? 631.
Other one ends in 613. That was ready.
Okay, 6613. Six 1-3. This is Robert Diggs Newsom.
Yes.
Calling case number 2334-6613, Michigan Z Properties versus Robert Diggs Newsom.
Good morning, Joe Horka, P75969, appearing for the plaintiff.
You see my hand up here, Carl.
Sure. Thank you.
Judge, it looks like he didn't make it out of 10. Is there any way to get him back in here where I can go back myself?
Let's see, he didn't make it out of room 10.
Right.
All right, let's get him back. Let's see. Those days.
What was he saying? He was just like Victoria Watkins and Larry Mason, and then yeah.
All right, so I'll call your case next, Ms. Watkins. I'm gonna place you on mute. Sit tight. We're in the middle of another hearing, but I'll call your case next. So Mr. Mason, Ms. Watkins is here under Paris's iPhone, but we're in the middle of another hearing. And please, Mr. This is Robert Newsom Diggs, who just came in.
Yes, sir.
Counsel. Okay, can you state your name for the record?
Robert Diggs Newsom.
Okay, Robert Diggs Newsom. Good morning. All right, attorney.
Judge, the parties are in agreement that, including the Jew rent, there is $6,865 due and owing. We'd like to enter into consent judgment with an installment payment plan, agreeing that $1,900 of that will be paid by May 26th, $1,900 more by June 6th, $2,065 by June 16th, and the June rent by June 30th of $1,000.
Mr. Diggs, is that your understanding of the agreement?
Yes, sir.
All right, is Is this in the form of conditional dismissal or consent?
A consent judgment, please, Your Honor.
Thank you. Please put your seatbelt on. Please don't drive until the end of this hearing. There's a consent judgment where $6,865 is to be paid in payments. First installment of $1,900, second installment of $1,900, $2,065, and then $1,000. This is to be paid on specific dates. Have you reviewed the consent judgment, Mr. Diggs Newsom? Mr. Diggs Newsom, have you reviewed the consent judgment?
Yes, sir.
All right, and do you give Mr. Horka permission to sign your name?
Yes, sir.
All right, the court is satisfied. Mr. Horka, send this in and try to get a copy to the other side if you haven't already. But Mr. Newsom, $6,865 must be paid. And what's the final date? What's the
Total must be paid by June 30th, Your Honor.
Yeah, the total must be paid by June 30th. There are several breakups in the payment. Please review our consent judgment. And if this total is not paid by June 30th, a writ may issue. Good luck. Good luck, Mr. Diggs Newsom.
Thank you.
You're welcome.
Bye-bye.
Thank you, Mr. Horka.
Excuse me, Your Honor. Have you called Jalissa Hill yet?
I'm not sure. Hold on 1 second.
McAfee, can you rejoin the breakout room, please?
Come on here, come on.
Mr. Mason? All right, when Mr. Mason is ready, I can call your case. It's Ms. Watkins.
Okay, Judge, I have Attorney Booth on the line again.
He looks like he's in room 9.
For nurse supervisor, dial 7015.
Mr. Martinez, do you have something ready?
Yes, I do, Your Honor.
Okay, 1 second. I'm going to call Attorney Spaniolo, then you. Keep your hand up, and then Mr. Horka. But I need 2 minutes.
Thank you, Your Honor.
While the judge is taking care of another matter, let me see. There's a person signed in under phone number 1039. What's your name for court? 1039.
Veronica Walls.
Pardon me, say it again.
Veronica Walls.
No, that's not the person I was speaking with. What phone number did you call in with Ms. Walls?
586-371-1039.
Okay, 1 second. And you said it's Veronica Walls?
The judge,
What's
the
your
judge
name?
asked
What's your name?
Veronica Walls versus Latanya Evans.
Okay, Veronica Walls.
Don't say my name.
I've been on here since 8:40. I'm actually sick.
Okay,
And
the
I'm trying
the
to.
judge will be with you shortly. I have your name placed in for the judge to call you.
I just want the could you please let the judge know the person does
Ma'am,
not.
don't go. No, don't go into your. You have to talk with the judge and your attorney. I'm just renaming everyone. There's a person signed in under iPhone. Unmute your device. There's a couple of people signed in under iPhone. The judge don't know who you are if you signed in under iPhone.
Hello.
Ms. McAfee?
Okay, it's not me. I was just making sure.
Oh yeah, we can hear you now. So you can mute your device. The court will be with you shortly.
Okay, how do I get in a break room? Because Mr. Connor is asking me to get in break room 6.
So if someone invited you to go into the breakout room, then accept the invite.
Where would it be? I'm sorry. Oh, I see.
It
Okay.
will pop up on your screen. Okay.
Hello?
All right, court. Okay, yeah.
Are you ready,
iPhone.
Judge? Okay.
Hello?
iPhone. Yes, what's your name?
I'm iPhone, but did you check in with my name is Michael Belcher. I don't know if I got called.
What's the case number?
I don't know, but my last name is Belcher.
Belcher, B-O-Z?
Belcher.
Belcher.
Belcher, okay.
Nice.
We'll check.
I believe it's one of mine, Your Honor.
Okay.
Is the case ending in 6625, if it's for Michael Belcher?
Michael Belcher, 662. We do have it. You're welcome. Okay. Here we have you checked in. All right, let's get this.
Oh, excuse me, I'm sorry.
Did you say me, Your Honor?
Yes, and Attorney Spaniolo, if you're still here. Oh, I think you're in the break.
No, it's your show. I'm on.
It's your show. We have so many. Please put your devices on mute. We can't get any silence in here. And if there's anyone else from legal aid who can take a phone call, I have an in-person defendant who needs to speak to legal aid. So if anyone can put a number in the chat where you can call, maybe do an intake, that'd be helpful.
Yes,
Mr.
Judge,
Mark.
I'll provide that phone number.
Okay. Mr. Martinez.
Good morning, Your Honor.
Good morning. What matter are you ready on the Sterling Watson, Candace Bailey matter?
I am, Your Honor.
All right, calling case number 2334-6597. This is Sterling Watson versus Candace Bailey.
Your Honor, James Martinez, case 6604 on behalf of the defendant. I think Mr. Watson is here.
Yeah, I'm here.
Morning.
Good
Mr.
morning.
Watson. All right. It's Candace Bailey here. And Mr.
Yes,
Watson,
I'm here.
okay, can you state your name for the record?
Candace Bailey.
And Mr. Watson, you don't have an attorney, do you?
No,
All right, can you state your name for the record?
Sterling Watson.
Thank you. And Mr. Watson, do you own the property at 19361 Kelly Road?
Yes.
Okay. Attorney Martinez, were you able to work out an agreement with Mr. Watson or some type of resolution?
Yeah, we're able to come to a resolution. We're gonna do a conditional dismissal with a June 9th move out date. 4B will be checked. I explained to Mr. Watson what that means, and the somewhat expedited process to get rid of Miss Bailey is not out on or before June 9th. I've also explained this to Miss Bailey.
All right, Ms. Bailey, do you understand the terms of this conditional dismissal?
Yes, I do.
All right, so if you do vacate by June 9th, your matter will be dismissed. In the event you don't, as Mr. Martinez advised you of, a judgment and a writ of eviction could enter at the same time.
Okay.
All right, so this is a termination of tenancy. There's not an amount to redeem the property. It's just purely a move out date. Please submit the conditional dismissal. Does Mr. Martinez have consent to sign your name?
No, he's gonna email it to me.
Okay, he's gonna email it to you. And Ms. Bailey, does Mr. Martinez have consent to sign your name?
Yes.
Okay, and Mr. Watson, you're gonna sign and send it back to Mr. Martinez?
Correct.
Okay, and I think, and you, Mr. Martinez, you'll submit it to court?
That's right, Your Honor.
All right, when the court is satisfied, good luck. Ms. Bailey, Mr. Watson, have a great day.
You as well, thank you.
Thank you.
Thank you, Your Honor.
All right, Attorney Spaniolo.
Hello, Judge.
Hello.
I'm ready to proceed with the default.
On Roxbury,
Yes, Your Honor.
does anyone live at 10917 Roxbury? Does anyone live on Roxbury, 10917?
Judge, the young lady was here, McAfee. I think she's in the breakout room. Remember, she had the deed. She sent me a chat and said she's in the breakout room.
If I remember correctly, Your Honor, respectfully, she was only disputing the ownership. She wasn't an occupant of the property.
Yes, I don't think she was an occupant of the property.
Okay.
Oh, Lord.
All right, so calling case number 233-46536. This is Evernest LLC versus all occupants of 10917 Roxbury Street.
Good morning, Your Honor. I'm sorry. Good morning, Your Honor. Attorney Paul Spaniolo, P72366, on behalf of the plaintiff in this matter.
Thank you. Okay.
Is the court entering a default on this case?
Yes.
It sounds to me like Ms. McAfee wants to essentially intervene. She's doing her best to get the occupant here, but I don't think a default is appropriate. That's all I'll say. Again, I don't have technically a client here, but I'm trying to assist with the logistics on this.
Is she saying that she doesn't own that she owns the property? There's an ownership. Is there an ownership issue?
Ms. McAfee, I just moved you back. The judge has called your case. You can speak on it. There is an ownership issue. That's all I'll say.
Yeah, I actually was on Zoom on my computer. Because I'm gonna have my uncle speak because he's having a hard time getting on the Zoom call, but he's actually occupying the space and he has been since for about a year now for me. We've been fixing it up because I have a deed here. It's here.
All right. Do you reside at 10917 Roxbury Street?
That's my property. That's why I don't understand. My uncle resides there.
Do you reside at 10917 Roxbury Street? Ms. McAfee. I hear what you said. What did you say?
I said yes.
Okay, and do you have an attorney?
Well, I guess the guy who I was just talking to was trying to be my attorney.
Your Honor, Attorney Brown advised me that she doesn't reside there, and I thought we established early on she didn't reside there.
That's what I thought too.
So I'm confused.
Well, it's my property and my uncle's there where we're both there fixing it up is what I'm saying. Nobody else is there. Nobody hasn't been there. And I'm so confused as to who would try to evict anyone besides me because it's my property. I have the deed here.
There are competing interests with the deed. So I agree with you that this would be messy and problematic, Attorney Brown. But all right, so Robin E. McCoy and Ance Curtis Phillips granted this property to SFR 3080 LLC, Delaware company. There's a management agreement with that Delaware company and Evernest LLC. So who are you saying owns the property? And because okay, let me ask you one more time. Do you reside at this address, 10917 Roxbridge?
Yes, me and my uncle has been occupying this space and fixing it up.
Okay.
I got the deed from May 17, 2020, Dion Thomas. He signed it over. This is my house. I have the deed here. I took it down to 36th District Court. I'm trying to get my uncle on the phone as well because we both are occupying the space. Nobody has been there. We've been fixing it up.
Spaniel.
Your Honor, thank you. So Ms. McAfee was present at the first hearing, just to give you some context, and she's called me twice regarding the deed. And so I took it upon myself to do some research on this. Her deed was dated May 17th, 2022. My deed is dated May 13th. The person, and I did a title search on Wayne County Register of Deeds, not just the free search, but an actual search. There has been no Dion Thomas in the chain whatsoever, Your Honor. The individual that sold to my client sold it to them on a warranty deed, and they were the owner of the property. The deed that Miss McAfee, that I suspect is the one that she's been showing you, is the one I pulled off the Register of Deeds, was a quitclaim deed for $4,000 by a Dion Thomas. And again, I went back to 2001. I'm sorry, no, 1993. There is no Dion Thomas in the chain, Your Honor, whatsoever.
And Mr. Brown, did you verify what Mr. Spaniolo had?
I haven't seen his deed. I've seen Ms. McAfee's deed. The part of the issue here, I think, is that Ms. McAfee's deed was actually recorded before Mr. Spaniolo's deed, so that, you know, makes things that much trickier.
Your Honor, that my deed was filed with the case, and I think that's why Ms. McAfee reached out to me, because I suspect, I don't know, but I suspect that she saw the deed in the filing.
No, I saw this that was sent to the eviction notice, which was very confusing to me.
Well, I'm not going to make a decision on who owns the property, but I can make a decision on whether the deed is acknowledged or not. There's one deed in the file, warranty deed in the file. I'm gonna, please submit your deed, Ms. McAfee.
To the 36th court.
Let's do a brief adjournment.
Okay.
Ms. council, did you have copies of the previous deeds that connected the change of title?
Are you referring to me, Your Honor, or Mr. Brown?
Yeah, I
Oh, okay,
know.
so,
And did,
well, I don't have it. It's reflected in the chain. And just incidentally, Judge, it's kind of, my client, there's a mortgage on the property. They actually acquired a mortgage and, well, strike that. My client's client, the owner, SFR308, they have a mortgage with US Bank. I doubt US Bank would extend any financing. That was, it's recorded October 25th of 2022. So, but to answer your question, no, I can certainly grab it and, go back on Wayne County Register of Deeds and pull that. But I would highly doubt the US Bank would extend financing to somebody if their title search reviewed or showed any, I guess, encumbrance or.
It's a lot of question. It's a lot of question about this case, but until I see deeds, I won't make a determination if there is a challenge of ownership.
Excuse me, am I supposed to
I'm going to
deed
set.
district court?
I just want to finish this sentence and then.
Oh, I'm sorry.
When is the best day for both parties to come back to present deeds and present their arguments on? I just want to see the deeds. If the deed, if it's a chain of title and your deed is out of the chain of title, I'm not going to make a determination on who owns the house. I'm going to get a confirmation that there is no different ownership and proceed with the eviction. That's all. That's what I'm doing. I'm planning on proceeding with the eviction. It sounds like this is a wild deed, an erroneous deed, but I'll still set a date to review everything because I don't have your deed, Ms. McAfee. So, and I haven't looked at.
Ideally, the earliest.
Say one thing, I did of course, so that's why I was asking, where would you like me to turn it into?
You can turn it.
I've done in to 36th district, turned it in, like that lady recommended me.
Okay, okay. What time can we come back? And by that time, if you sent it in, we'll have all files that were sent in. They'll be with the file. So what's the good day?
Would the court be amenable in 2 weeks, Your Honor?
Yeah, 2 weeks will work.
The phone's kind of breaking up a little, but weeks good.
May 30th. May 30th.
May 30th.
2023.
What's the time?
At 10 a.m.
Okay.
Thank you, Judge.
You're welcome.
Thank you, Your Honor. Ms. McAfee, could you give my phone number to your uncle so that he can call me? Okay.
She lives there too, so you're expected to be there, Ms. McAfee.
I will.
You're a resident.
All righty.
All right.
Are we all done? Or?
Yep, you all are free to go.
Thank you.
You're welcome. Attorney Wood. And then this.
How can I hang it?
Yes, Your Honor.
I'm sorry, Attorney Wood. 1 second. I have someone in person. I want to make sure I can get him to legal aid. I don't see the other attorney here. So, okay, we can call your case, counsel. Is this the Heather Burks?
Yes, Your Honor.
All right, calling case 2-3-3-4-6-5-8-9, Larry Mason versus Heather Burke. 6-5-8-1 is Larry Mason present? Mr. Mason?
Yes, Your Honor. Larry Mason.
Thank you.
Phyllis Wood, P 74800 on behalf of Ms. Burke. Your Honor, we've agreed to a 1-week adjournment to resolve this. The parties are in negotiations for a potential settlement. Additionally, I've been unable to serve my appearance or the answer on Mr. Mason as I didn't have his contact information. So for those reasons, we're asking the court to grant us a brief adjournment.
All right. Is brief adjournment like May 23rd, brief?
I would agree to that.
I agree as well, Your Honor.
Okay. To May 23rd at 10 a.m.
Thank you, Your Honor.
Well, hopefully you all can work something out in the meantime. You have proof of service. And did we complete Victoria Watkins' case?
No, Your Honor, but she is present.
Okay, oh yeah, she had to go back. All right. So calling case number 2-3-3-4-6-5-8-0-0. This is Larry Mason versus Victoria Watkins. Please state your name for the record.
Larry Mason.
Victoria Watkins.
Thank you, Ms. Watkins.
May 26th at 10.
No, May 23rd.
All right, were parties able to work out a resolution?
No, Your Honor.
No, Your Honor.
Okay, how much, this is a complaint to recover possession of property. This is not recover rent, this is a termination of tenancy. How much time is needed to vacate?
I need a little bit more time. I'm looking around, at least if I can, 3-4 weeks.
And Mr. Mason, how much time are you willing to offer? Ms.
I would offer her 2 weeks. I would really ask for 10 days, but in this situation, I'd be willing to afford 2 weeks. There's several other issues that are affecting other tenants based on her tenancy, and I have a responsibility to them. So the sooner I can put her out would be better for the rest of my tenants.
All right, Ms. Watkins.
Yes, Your Honor.
We're at 2 weeks. 2 weeks will put us at the 16th at May 30th. So June 5th would get you to June 2nd. All right, court's gonna do a hearing by judgment. Well, is there any objection to an all occupants judgment? It's totally up to you, Mr. Mason.
I'll let that slide. I'll go ahead. All occupants is fine.
Okay, Mr. Mason was willing to remove your name from the judgment, Ms. Watkins. So it's an all occupants judgment instead of judgment in Victoria Watkins. But all occupants must vacate by June 2nd, 2023, or a writ may issue. June 2nd is a Friday, so a writ of eviction can't be filed until Monday, June 5th. So you get that weekend, but June 5th, a writ of eviction can be filed. So you must vacate by June 2nd, but a writ of eviction can't be filed until June 5th, which is that following business day.
Okay, Your Honor.
All right, it's a hearing by judgment. All vacate 2nd, 2023. Thank you. Parties and Mr. Mason, please submit a judgment to the court.
Yes, Your
Okay,
Honor.
thank you, Your Honor.
You're welcome.
Have a good day.
And I only have one more case with you today, Your Honor, and it's going to be a default judgment if you can hear it.
Is that Nathaniel Driver?
Yes, Your Honor.
Is Nathaniel Driver here? Does anyone live on Sharon? Anyone live on Sharon? Calling case number 2334-6579, Larry Mason versus Nathaniel Driver and all occupants on Sharon Road. May I have your appearance, counsel? Mr. Mason.
Larry Mason.
All right, thank you, Mr. Mason. Is Nathaniel Driver here? Nathaniel Driver doesn't appear to be present. No one has answered the call of the court for that name or the address on Sharon. No one resides at Sharon. Defendant has failed to appear. Counsel, Mr. Mason, are you requesting a default judgment?
I am, Your Honor.
Default judgment is granted. Defendant must vacate by May 26, 2023, or writ may issue.
Thank you, Your Honor. Enjoy the rest of your day.
All right, you too. All right, L. Evans, Ms. Evans.
Yes,
You had your hand up.
yes, my lawyer and landlord is here. I wonder why I haven't been called yet. I've been on this line since 8:30.
Your lawyer's here. Once your lawyer notifies the court that they're ready, then I'll call your case.
Your Honor, I just got back from the breakout room with the landlord on that one. I think we are ready to go. I'm moving the landlord back now. She's on the phone.
Okay. And Mr. Clark, what are you on? Mr. Clark, are you on the case with Sherry, Darius Clark and Asia Clark?
No.
Okay, so you on? You have your case number?
Yes, it's 233-46622.
Okay, you're with Attorney Gann. So that's let's see who's in here. Gann's office. I just saw her. I think it is Attorney Gann. Have you spoke to anyone?
No.
Okay, let's see where she is. Attorney Spray. All right, do you want to speak to an attorney? Or do you just want to speak with the landlord's attorney?
I can speak to the attorney.
All right, this is what I'll do. If your deal doesn't work out, Mr. Clark, or if you want to speak to a landlord attorney, or if you're confused when you're speaking to claims counsel, then just ask her and they'll send you to legal aid.
Okay.
I think you all may have be able to work out a resolution. So I'll leave it to you and Attorney Spray and counsel. If he asks for an attorney and you all can't work, please forward him to legal aid.
Good morning, Your Honor. Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff. My apologies, I was on record in another court. Could you please do a brief overview?
I'm just inviting you to a breakout room.
Okay, thank you.
Is Anthony Johnson here?
Yes.
All right.
Anthony Johnson is here.
And do you have an attorney, Mr. Johnson?
I'm not sure. I had picked up counsel at the last court hearing, but as of yesterday, at the final hour, Judge, I received a letter, correspondence from the attorney stating that due to short staff and no funding, they cannot take my case.
Okay, well,
At least not take my case, but at least they can't continue on in my case.
okay. Well, y'all need some gas to keep the engine running. So maybe it was one case too many, Mr. Johnson. But this is what we'll do, Mr. Johnson. I can put you with plaintiff's counsel, just like I did the previous case. And if it works out, it works out. If you insist on counsel, then I'll give you a brief adjournment to sort it out. But
well, at this point, Your Honor, I don't want to come across to the court as though I'm being vexatious or anything, because after all, I mean, if Lakeshore corresponded, if that was what they stated yesterday with regard to not being able to handle the case or continue the case, well, come on, Your Honor. They knew that at the time they picked the case up on May 16th.
yeah. Also, it's free.
I get that, but also there's a right to counsel ordinance that's just been put in place from the city. And so my thought is, if the ordinance is on the books, Lakeshore and other agencies shows up at the city council to buck and argue and ask for the money to run their programs, then they should have these programs well thought out so that when litigants like myself show up, they don't have to take my case and then 2 weeks later, for whatever reason, decide to snub my case.
I understand what you're saying. And as a judge, I'm not pro Lakeshore and I'm not pro plaintiff. I try to remain as neutral as possible. Now,
well, you know, also, Your Honor, it concerns me. It concerns me, Your Honor, because so their counsel at least should have shown up today to say, okay, Your Honor, we're going to withdraw as counsel. Here's an order to withdraw as counsel. None of that. So, I mean, to leave me out here to try to reach a resolution with the plaintiff's lawyer, which, by the way, I'm totally on board with. I'm not, in other words, I'm not turned off to it. I mean, I'm really trying to resolve this in an amicable and civil way. But at the same time, just don't leave me out here. I mean, you could at least shown up to the court today and explain to the judge, or to the court, that, hey, we're not going to continue on in the case.
I understand. That's fair, Mr. Johnson. I'm not agreeing with you and I'm not disagreeing with you. How about that?
Well, I think you should be agreeing with me, but okay, I respect what you're saying, but I don't agree with your statement. I'll just say it that way.
Well, yes, I have to allow both sides based on the ordinance. Pursuant to the ordinance, I have allowed Lakeshore Legal and United Housing Coalition and Michigan Legal Services to speak to the defendants and to represent everyone in here. And it's within your right, it's within their right. So I don't know the inner workings of it, but Attorney Gann is here and we appreciate your thoughts. I'm not part of Lakeshore Legal, but Attorney Sprague is here from Attorney Gann's office. Okay. So she's in a breakout room with someone now. If you place your hand up in the chat, I won't forget about you. And that way, when she comes out, I can alert her to you and invite you into a breakout room with her. But court understands your position.
Okay, real quickly, there was also a failure to appear placed on the record with regard to last hearing on May 16th. I just wanted to show the record that I was present and on time at court on the 16th. So why that failure to appear reached the court, I'm not
Your
Sure.
Honor.
If it fails to appear, it doesn't matter in this matter. It won't have any effect on your case. And Mr. Martinez,
Yeah, I can talk to Mr. Johnson. I have capacity and I have no problem talking to him, and maybe we can negotiate a resolution on his behalf today and keep the case moving.
room number 11.
Appreciate you, Counselor.
No problem, sir. I'll see you in room 11. Thank you, Your Honor.
Come on. Good luck. Room number 11. All right. Attorney Snyder.
I have two resolutions for 545 and 546.
On case number 23346545, this is Shirley Hawkins versus Vanessa Reed. Find out.
Self-pleasure does not make you gay.
Just turn away. Turn away. I tried to catch you. I couldn't catch you. Time. I'm sorry. But that's why we're going back in person. That's why we're going back in person. All right. Let's not let that occupy too much of our brain. And be careful while you drive. And yes, yeah, calling case number 2346545. Shirley Hawkins. See, that's why I'm putting earlier in the court hearing when someone was playing music. You all didn't understand what I was saying. Now you understand what I'm saying. All right, Shirley Hawkins versus Vanessa Reed and all occupants.
Thank you, Your Honor. Jackie Snyder Powder on behalf of Mark Wesbury, 82554 is my P number, and we represent Shirley Hawkins. Ms. Reed is present in the courtroom. Ms. Reed, if you can unmute and state your name, please.
You're not shell shocked.
No.
Right. Ms. Reed. Oh man. Ms. Reed, are you present in the courtroom?
Vanessa Reed?
Yes.
There she is.
Okay. Can you state your name for the record?
Yes, Vanessa Reed.
And you are fortunately calling in on the telephone, Ms. Reed. All right. Counsel, can you put the terms on the record?
Yes, Your Honor. We entered into a conditional dismissal in which Ms. Reed agreed to vacate by June 20th.
Okay. Very straightforward conditional dismissal. Vacate by June, you said 20th?
Yes, Your Honor.
Vacate by June 20th, this matter is dismissed. In the event parties don't vacate by June 20th, a judge, is 4B checked?
Yes, Your Honor.
Box 4B on the conditional dismissal is checked, which means that a judgment and a writ of eviction can be entered at the same time. So we don't have to come back to court to enter a judgment and a writ of eviction. So just want you to be aware of that. But this matter will be dismissed. If you vacate by June 20th, it will a judgment and a writ will issue if you don't vacate. Ms. Reed, do you have any questions?
No, sir. Thank you.
And I did ask Ms. Reed if I could have permission to sign her name on the conditional dismissal, and she granted it to me in the breakout room.
All right. Well, the court is satisfied. Thank you, Attorney Snyder. Thank you, Ms. Reed, for your patience. And I think you chose the best method of logging into Zoom today, Ms. Reed.
Okay. Have a blessed day. Thank you.
Thank you, Ms. Reed.
Do I hang up or what do I do?
Yes, you can hang up. You're all done.
Okay. Okay. Thank you too. Have a good day.
You too. All right, we're slowly plugging away, everyone. So maintain your patience and we'll try to call your case next.
And Your Honor, Mr. Chambers was in that as well. So we're ready for his case whenever you're ready.
Fantastic. Calling case number 2334-6546. This is Shirley Hawkins versus Vincent Chambers.
Thank you, Your Honor. Jackie Snyder-Poudar on behalf of Mark Wasbury, 82554 is my P number. And we represent Shirley Hawkins on this matter. Mr. Chambers is present in the courtroom. Mr. Chambers, if you could unmute and state your name, please.
Yes, Vincent Chambers.
Thank you, Mr. Chambers. And were parties able to work out some type of agreement?
We were, Your Honor. We entered into a conditional dismissal as well, with 4B checked for a move out of June 20th.
All right. As stated in the previous hearing, 4B means that a writ of eviction and a judgment can simultaneously be filed. What is the move out date again, counsel?
It is June 20th, Your Honor.
June 20th, 2023. So, Mr. Chambers, you're agreeing to vacate by June 20th, 2023. Make sure you get the keys to the appropriate party before vacating, and upon vacation, your case will be dismissed. In the event that you stay beyond June 20th, a judgment could enter as well as a writ of eviction. Do you have any questions, Mr. Chambers?
No, sir.
All right, well, good luck. And does Ms. Snyder have permission to sign your name on the conditional dismissal?
Yes, sir.
Okay, all right, have you, make sure you get a copy of it or view it. Ms. Snyder, however, you'll get a copy from the court, but those are the terms, and if you need a copy, Ms. Snyder can give it to you.
Yes.
But you'll get a copy from the court in the mail anyway, but I just wanted to let you know. All right, so good luck. Thank you, Mr. Chambers.
Okay, thank you.
Thank you. You're all set, Mr. Chambers. You can disconnect.
Okay, thank you.
And then how is it going with the Mr. McElroy in the courtroom, Your Honor?
Okay, I think we need to adjourn this matter. Is Mr. Keenan in the building? Mr. Keenan?
Yes, Judge, I'm here.
Were you able to speak to Mr. McElroy?
I have not spoken. Is this I didn't hear the name. I haven't received a phone call. Did you see my direct line that I chatted to you?
Yes, I received your number,
okay,
and I gave him your number to call with the extension and your name. And I think it'll be reasonable to adjourn this once and then maybe recall it. That'll give everybody some time, but he didn't have his phone in the courtroom.
Okay.
So,
yeah, and if you're able to chat me his phone number, I might be able to, we can have 2 lines of communication going to get this moving along, but an adjournment would be great.
We could have a very short adjournment, Your Honor.
Yes, like next week.
Yeah.
Okay,
May 23rd, does May 23rd work?
let me check.
Yep.
Yes, May 23rd is good.
All right, calling case number 2334-6544. This is Rose Community Management versus Dexter McElroy.
Thank you, Your Honor. Jackie Snyder-Poudar on behalf of Mark Wasbury, 82554 is my phone number. And we represent Rose Community Management for Square in this matter.
All right, thank you. And let's see. Court finds Mr. McElroy was here. He requested counsel. He was here in person. Unfortunately, you all weren't able to work out a resolution, and you suggested as well as he requested counsel. So I'll allow him a week to speak to counsel, and we'll be back May 23rd at 10 a.m. Mr. Keenan, I don't have his contact information, unfortunately. I wish I would have gotten his number, but he has your information and calls.
Yes, yes, just Judge, for the record, Kyle Keenan, P86413 with Lakeshore Legal Aid. If I'm able to reach Mr. McElrath and do an intake, I will. And hopefully he reaches out to us.
All right. Okay. Thanks, Mr. Keenan.
Thank you, Your Honor. You have a great day.
All right, you too. Attorney Sprague.
Yes, Your Honor.
Yes. Do you have a matter that is ready?
I do. It is the matter of Marwood versus Anthony Johnson. It is case number.
Oh, okay. Calling case number 2-3-3-4-6624. This is Marwood Marston 2020 LLC versus Anthony Johnson.
Good morning, Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff.
Good morning.
And my apologies. I did the wrong on case. This is actually for Mount Vernon versus Antonio Clark.
Okay. Let's see.
And that is the case ending in 6622.
Gotcha. No problem. Let's strike this case number and we'll go case number 2-3-3-4-6622 Mount Vernon Apartments versus Mr. Antonio Clark and all occupants.
Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff.
Thank you. And Mr. Clark, can you state your name for the record?
Antonio Clark.
Thank you, Mr. Clark.
Welcome.
All right, were parties able to work out some type of resolution?
We were, Your Honor. We've entered into a conditional dismissal. Mr. Clark has indicated that he has the ability to provide payment of $500 weekly, beginning on May 19th of 2023. We do show that there is a current balance of $1,366 in past due rent, court cost of $160 for a total doing of $1,526. Those payments will be made in addition to June's rent. And that would be with box 4B and box 7 checked.
Okay, and rent is $791, correct?
$790, Your Honor.
Okay, $790.
It looks like it was just recently reduced by $1.
Okay. So this is a conditional dismissal. 4B is checked with defendant to pay $500 per month in addition to his rent. Is that what the agreement is?
Yes.
Or per $500 per month or week?
$500 per week on a weekly basis beginning on May 19th.
Starting May 19th. Okay, so $500 per week starting May 19th at 1, 2, 3, 4 weeks. Should be around 4 weeks plus the $790 rent. So, okay, so is there a deadline to this?
Yes, it would be a payment of $500 on the 19th, the 26th of May, and June 2nd. And then on the 9th, he would be responsible for the $26 remaining.
All right, and is that your understanding of the agreement, Mr. Clark?
Yes.
All right, the court is satisfied. Mr. Clark, do you give permission to Attorney Sprague to sign your name, considering the fact that you're in 2 different places right now?
Yes.
Okay. All right, the court is satisfied. Good luck, Mr. Clark.
All right.
And take care.
Okay, you too.
All right, thank you. All right, is Xavier Lewis here? Xavier Lewis? Is Daisha Beckham here? Maurice Thompson.
On occupants of 206 days back.
Maurice Thompson
Okay.
is here.
Are you representing the council? I see council on your, I see there's Attorney Reimers here. All right. Devon Belt, he's in the waiting room right now. It's great he named himself. Now black people.
Excuse me, Your Honor, did you call Deja Beckham?
Deja Beckham, yes, I did.
I'm an occupant in the house, so I was speaking on her behalf.
That's fair. It's the defendant too is all occupants. So you have standing to speak if you stay in that house. All right. Do you want an attorney, or do you want to speak directly with the landlord's attorney?
I can speak directly with the landlord's attorney.
Okay. And you're Mr. Pop. You're Paul on here?
Yeah, Mr. Pop.
Mr. Paul, I'm going to place you into a breakout room with Attorney Sabree, okay? Breakout room number 10. Is Sharita Rose here? All right, iPhone with your hand up.
Tiana Jackson.
All right, Ms. Jackson, and are you a landlord or a tenant?
Tenant.
And I see you're with Sean Tate.
Yes.
Is Tate ready for this matter? I know he's in another court, so whenever he's back, I can call the case.
Okay. Thank you.
So kind of tied to him in a sense where when you all are both ready, obviously you're ready, but when he's ready, then I can call it.
We'll let
Okay,
Sean
thank-
Tate know, as well as Marie Reimers. She's in Judge Jacquet's courtroom. We'd let her know, and she has 4 hearings, and then she'll be over.
Okay.
That was for 628.
628.
Maurice Thompson.
Okay. I really have to keep those devices on mute.
Excuse me, Judge. Hi, my name is Arquisha Dunbar. My time was at 10. While I was getting on the phone, it disconnected me twice, so I had to call again. I've been on the phone since
Sorry, you
10.
didn't get default. You didn't get default. Do you have an attorney, Ms. Dunbar?
No. When on May 16th, after the hearing, they appointed me to the breakout room, but I never got in touch with an attorney at all.
Okay. Do you want to
I was
speak
sitting
directly?
online for a while and hung up.
All right, Ms. Dunbar, do you want to speak directly to the plaintiff's attorney, see if you all can work a deal, and then if you need counsel, proceed?
Yes.
All right, let's do it like that, because I know they're short staffed today. If you need counsel, Mr. Horka can send you to legal aid, so.
I'll pull her into a breakout room right now. I have a few ready when I get back.
Okay. Madam Clerk Reporter, you want to take a 5-minute break?
I sure do.
All right, let's take a little Gatorade break.
Yeah.
We'll be back at 11:30. I know that's more than 5 minutes. We might be back earlier. Keep the negotiations going. I'll call whatever cases are ready.
Your Honor.
Break to 11:30.
May I be put in a breakout room with Afonso Thomas and his attorney if he has one? I think we can get this resolved pretty quick.
Okay,
Thank you.
you're welcome. Did I put you in 6?
That'll work.
Now, did you see an invite, Council?
I did. I'm going there now. Yes.
Okay, it's 6, yeah, all right.
Thank you.
Excuse me, Judge.
Yes, sir.
I was just making sure I was checked in.
Mr. Biddles, you're on 599. Let's see. 599, Clifford Biddles, you're the landlord, correct?
Yes.
Let's see if anybody is here from your property. And that way, we take this little 5-minute break.
I appreciate it.
You can talk in the meantime. And I'll give you breakout privilege.
Yes.
I give you co-host privileges, so then you can move in and out of the breakout room.
Thank you.
You're welcome. Okay, does anyone live at 3777 Clements Street?
Yes.
All right, Mr. Wilcoxon, do you have a man? Mr. Wilcoxon, do you have an attorney?
No.
All right,
No, sir.
Are you requesting counsel? Are you requesting an attorney?
Yes.
Okay, is Lakeshore indeed overwhelmed today? Is that the case? I just want Attorney Keenan, are you all able to represent anyone else?
Yeah, I could speak with them.
All right, well, let's keep the ball rolling. Okay. All right, Mr. Wilcoxon, I'll invite you into a room with Ms. Van Blair. You all, and then Mr. Biddles, that attorney will talk to you, okay?
Okay.
All right, so sit tight, but the ball is rolling.
Okay, thank you.
Excuse me, Your Honor. Can I request legal counsel as well?
Yes, does anyone see who is saying that?
This is Jalissa Hill saying that. Jalissa Hill.
Listen Hill. What I'll do, Ms. Hill, I'll invite you to Lakeshore Legal, and that way, whoever comes can speak to you, whoever comes first, whoever's available. Good luck. All right. Gatorade break as promised. Nothing's going on the record for the next until 11:30. So my court reporter can get a quick break, and then we'll finish through and push through another hour. But we'll get through all these cases. So the restroom, grab something, eat, talk to the defendant, talk to the plaintiff, do whatever you need to do. A brief break.
Okay.
Is there a plaintiff's attorney here for 23346-629?
Mr. Thomas?
Yes, it's Mr. Thomas.
Hey, it's Paul again. Meet me in breakout room 6 again.
Okay.
Thank you.
Who was the attorney representing for Mr. Gann, for the officer Gann? Okay.
Never mind, just staring down there.
Mr. Thomas? Alfonso?
Hello?
Mr. Brown? Attorney Brown, do you have a map? It's ready.
I do. That is the Walls v. Evans case.
See last three. Counsel.
Last three are 568.
568. On case number 2334-6568, this is Veronica Walls versus Latanya Evans. Is Veronica Walls present?
Yes.
Can you state your name for the record?
Veronica Walls.
Thank you, Ms. Walls. And
You're welcome.
is Ms. Evans here?
Yes,
All right, can you state your name for the record?
Latanya Evans.
All right, counsel, I can't remember if you put your name on the record yet, but.
Yeah, but Your Honor, Connor Brown, P79949 on behalf of the defendant.
All right, thank you. Have parties reached a resolution in this matter?
There's not been a resolution, Your Honor. I think it's pretty straightforward, though. Both parties at least agree that Ms. Evans needs to move out. The situation is untenable. Ms. Walls obtained a PPO against Ms. Evans, I believe without a hearing, but that obviously complicates matters. Really just looking for a final order that gives her some time to get her things and move out of the property, and also specifies that her being there during the remaining time period in which she has possession doesn't constitute a violation of the PPO. That's it. I think if she could have 30 days, that would be sufficient.
Okay.
She's been out of the property, since the order was entered, for obvious reasons.
Did you put a hammer to the wall, Ms. Evans?
No, I did not, sir.
Okay. All right. You know why I'm asking that, Ms. Evans?
Uh-huh.
Okay.
I don't know why. I would like to hear it.
As long as you didn't put a hammer to the wall, that's okay.
Okay.
You said 30. Our parties amenable on a 30-day move out. The parties agreed to a 30-day move out. Ms. Walls, what's your request?
Your Honor, no, I don't agree to it. I served her way in March. She had plenty of time. She called me during the PPO and said, "Can I come and get my things?" I said, "Sure, as long as you accompanied."
Sir, she did not give me anything until the day that she gave me the PPO,
Your
sir.
Honor, I have this on text message as well. She texted me and said, "I'm going to meet I'll show you the text message." She said, "I'm going to meet the."
Hold on, Ms. Walls. I muted you. I'm reading the text messages. That's why I asked her, did she put up a hammer through the wall? Okay. I don't need these text messages read and revealed to the rest of the world. I just want to know how much time are you willing to give her? And I'm going to unmute you. Star 6, Ms. Walls. So how much?
7 days is efficient. She
Your
turned
Honor,
off the
I cannot
light.
move a whole house out in 7 days.
You don't got no whole house, Your Honor. I wish you could come up there. It's nothing but junk. I sent you pictures.
All right, I have to mute both of you all. 10 days is the statutory minimum. Mr. Brown?
Yes, Your Honor, as I said, Ms. Evans hasn't been in the property because of the PPO. So she hasn't had an opportunity to pack any of her things at all. She's trying to comply with the law and not get arrested. So as I said, if the court could put something in the final order that says her being there to at least pack up her things and move out doesn't constitute a violation, and provide her 30 days, I think that's fair. It would at least give her an opportunity to move with some dignity.
Okay, Ms. Walls, is there currently a PPO against Ms. Evans? Is there a person?
Yes, it's a PPO. Yes, it's a PPO. This girl opened up my car door, swung at me, and spit in my face. Yes, absolutely. And the police, the detective already said that when I talk to you, Your Honor, they will be there. They know her like her name is Evans. They know her.
They know her.
How do you all
anyway, the bottom line, it has not been no problem for her to get her.
So you do have a PPO?
So how can I come and get my stuff if you got to?
All right. All right.
That's the gist of it.
Okay. So I think it's established that. All right. The court's going to allow. And Mr. Brown, if you'd like to draft up a simple order, okay? I'm gonna do a judgment. I'm gonna unmute you, Ms. Walls. Ms. Evans, I'm gonna keep you muted. You have an attorney, okay? He can speak for you. *6, Ms. Walls.
Yes, Your Honor.
All right. If there's a PPO, Ms. Evans still has to be able to retrieve her items from the property.
Let me tell you something, Your Honor. That lady there's no problem for her to retrieve her. She literally texted me and called me and said, "Bitch, I'm not moving nowhere." She told me this over a month ago. This girl has.
Ms. Walls, stop cursing in court. I read the text messages. I've read them all. Okay? I read them.
You did?
Yes.
The police already told me we will be there.
All right. Okay. This is a judgment. Court's going to enter a judgment by hearing where defendants must vacate. Ms. Evans and all occupants must vacate within 21 days. 21 days from the 16th of, so 1, 2, 3, 4, 5, 12, 13, 14, 15, 16, 17, 19, 20. 21 days will be June 6th. So you must vacate June 6th, 2023. In the meantime, parties are not, Ms. Walls, you're not to engage with Ms. Evans in the process of her vacating the property. Ms. Walls, you must leave the property. How do you want the keys? How would you like her to return?
I want the keys. The police already gave me the keys. Your Honor, the house has to be clean. Do you understand? She turned the lights off, and it's magnets and roaches all in the kitchen. The food and everything it's summertime. It's spoiled. She could have notified me. She didn't say nothing.
Ms. Evans, Do you still have items in the home?
Your Honor, I have not been there. If the lights was cut off, they was cut off because of not payment or something. I don't know what she's talking about.
Do you have items in the home? Does Mr. Brown, does she have items in the home?
Does, Your Honor.
All right, okay. So the court's gonna retract the 21 days, okay? Because it may be an issue. But Ms. Evans gonna answer the question. Ms. Evans.
You had me muted, Your Honor. I have a whole house of things. Me and my children things.
I'm muting you again. I just muted you again because you won't stop talking. I'm gonna unmute you one more time. I'm gonna ask you a question. Do you have food and items, perishable items in the house?
Yes.
All right. I'm going to order you to visit the home. If you need 21 days to move out, you can't leave it. All right. If you're not in the home, why do you need 21 days? Why do you need 30 days?
I need to be in the home to move my stuff and pack my stuff and throw out stuff I don't need, Your Honor. I have not been there. All my personal stuff is still there.
How much time do you need to do that?
30 days. I have to find a place to put the stuff.
All right, well, as it relates to the garbage and anything that's in the house that's perishable, please clean it out.
Okay, I will, Your Honor.
You have until June 6th to vacate the property, or else a writ of eviction can be issued, okay?
Okay, thank you.
You are not to have any contact with Ms. Walls. Ms. Walls is not to have any contact with you. Please coordinate a way through your attorney to leave the keys. Ms. Walls, you said the keys are with the police. How is she supposed to be able to access the house?
She's muted, Your Honor.
Okay, yeah. *6, please.
Your Honor, I have the police gave me the keys. She is to be escorted by the police, and they will let her in. Soon the police come to the premises. She ain't never been denied to come in that with the police. Period.
All right, this is what we're gonna do. You can't restrict her ability to go into the house. I'm going to reduce this to June 1st because I think this property is going to be, if they're groceries, she can't get in the house, the property's going to be in bad shape, and you will have some type of infestation.
Your Honor.
Plaintiff just indicated that essentially she's already locked the defendant out. I'm not sure that that's a good reason to reduce the amount of time. I was just going to ask if the court.
Exactly. I need more time than what you're giving me.
Ms. Evans, please.
No, you don't.
I was going to ask if the court could order Ms. Walls to at least return possession to Ms. Evans for the remaining time that she has, so that she can get in and out and move. She can't have the police there, 24/7 for the next 3 weeks. That's just not feasible. She left.
She can come get her stuff today.
Ms. Walls.
Her stuff today.
Ms. Walls, you're illegally locking out Ms. Evans. That's what you're doing right now. That's really what you're doing. It's a lockout. You took her keys away. She can't get in the property. Whether you want her out, whether she's making a mess, whether she's got ketchup on the walls, regardless, she needs access to her house. You all have a PPO. So how is she supposed to get these keys to even clean out the house? Please give me the answer to that, please. How does that work?
Your Honor, I stay downstairs. When she has the police with her, she can come in that house today.
It's not about the police, because you're not going to stop talking when I start talking. So I just mute you and I'm going to unmute you. But it's not about the police. It's the police can't control Miss Evans. The police aren't ordered to give her permission to enter the house. I never ordered that. She's supposed to be able to use her keys and move it out without a person with a gun and a badge behind her. That's what happened after the move out date. That's what happens after the move out date to remove
But get
her.
the phone off me.
You're
I'm on the
essentially-
phone. You can't climb the phone.
So, Ms. Wells, I think you need to figure out a way to provide access to Ms. Evans, and June 7th to be the day that you're eligible to file for an eviction. She has until June 6th to vacate.
I'd,
figure-
I'd still ask the court to extend that time a little bit. I mean, she really have even the opportunity that a person would normally get under a regular 30-day notice, because normally you can be packing your things and moving during that time. But if you are immediately banned from the property by a PPO issued at an ex parte hearing, you maybe have time to grab your purse or something, but she hasn't had time to even start packing or thinking about packing.
Your Honor, that is not true. She cannot.
Did you read these text messages, Attorney Brown?
Sorry?
Did you review the text messages that were provided?
I have.
You got the one she provided. I have all my texts too.
Please provide it to him.
That's the final order of the court. Ms. Evans, you have 21 days. Ms. Evans, you must provide access. No, Ms. Walls, you must provide access immediately to Ms.
Absolutely, she can come today. She can come today.
You must give her the keys. She can come.
No, she's not. She's not going to get a key to my property because, first of all, she's dangerous. Number one, anytime you open up my door and swing in my face and spit in my face,
you swung on me.
You know what? I didn't already press charges.
All right, Ms. Walls, this is how it works. I'm called a judge. I have a robe on. I work at 36th District Court. I was elected by the people of the city of Detroit to administer justice. When people don't listen to me, I can drop the gavel and order whatever I want to order within the court rules. This is one of those situations. Ms. Evans is allowed to access the property for 21 days. If you have a personal protection order, then place the keys in a lockbox. Give Ms. Evans the code to the lockbox. She has access to the house without any police, without any administration from you until June 6, 2023. That's a 21-day period. Within that period, she can choose to clean up, she can choose to move out. On June 7th, you will have the legal authority to apply for a writ of eviction. With that writ of eviction, you'll be able to call a bailiff, order a dumpster as required by municipal code, and conduct an eviction. And then you'll have full use and enjoyment of your house. But don't tell the court that you're not going to provide access, because that's not only going to further your goal of getting your property back, but it can also hold you in contempt.
Your Honor, she has destroyed and broke windows. Ain't no way in the world I trust her, period. She done bust windows.
She's lying, Your Honor. She's lying on me, Your
Okay, Ms. Evans. Ms. Walls, I'm going to unmute you. I just want you to know that this is a court order. This is not an option for you. This is a court order. And you have every legal right to file a case against Ms. Evans for damages caused to the property. This is for possession.
I'm doing that. I'm doing that. That's in place right now.
all damage before it happened. I have a report number and everything.
Is it clear? Are you clear on the orders from the court?
I hear what you're saying.
Okay. Do you understand that you
Okay.
have to provide access to,
Yep,
to
she's
Ms.
been here extra.
Keys without the necessity of you or police being there? She is.
The police gonna be there. I don't trust her 1 inch, not one bit.
You need to give her, just make it clear, the order shall state, Ms. Evans has.
Okay, well, you know what, Your Honor, I respect what you're saying, but you know what, I'm gonna rebuttal.
What, you wanna go to jail? Well, what, you wanna go to jail or something? What's the but? I wanna hear the but part of this.
I said, I'm gonna rebuttal that.
Okay.
So, Your Honor, I respect what you're saying, but I'm gonna rebuttal that. I'm gonna file a motion because ain't nowhere in the world somebody gonna sit there, tear my property and attack me and approach me the way she did.
She's lying, Your Honor. She's lying.
You know
And
what?
there's no witness.
All right,
Okay,
that's
you know what? Y'all, I'm not.
That's the
She's
final
the
order.
next door witness to tell you that she's lying.
Mr. Brown, you're very important in this matter, and please draft up that order. And
I'm happy to do so, Your Honor. I don't know if the court wants to schedule a show cause hearing in advance if Ms. Walls is saying she's not going to restore possession to my client, but
is that the case? Is that the final? Is that the case, Ms. Walls? Do you plan on restoring possession as ordered by the court?
I didn't hear you, Your Honor.
Do you plan?
I didn't hear you.
Do you plan on providing access to Ms. Evans after this hearing?
I'm going to provide access to the hearing. She called me and let me know when she coming, then she can come.
No. Ace Hardware or Home Depot or Lowe's. You go there, you ask them for a lockbox. You tell them you need a lockbox. Because the judge ordered you to purchase a lockbox. And you put that lockbox on that doorknob. And you put those keys in that lockbox. And then you text Miss Evans the code to that lockbox. Or you all communicate. Or you slap it on the backup. Don't slap it on the backup. But you text Miss Evans and let her know. And that's the way you're to provide access to this property.
She got access to her property. She did it before. She going to pick her up with the police.
So, Mr. Brown, please just put in order that Ms. Walls is to provide keys and access via lockbox and provide the code via text to Ms. Evans. Judgment by hearing, not by consent.
good.
Day of June 6, 2023.
Okay, and it'll be an all occupants judgment.
I will have to get her to consent to that. Actually, I don't know if I can. I really don't know if I have authority to.
I think the court has discretion to do that. It's
all occupants must vacate by June 6, 2023.
Very good. Thank you, Your Honor. And last thing, can I include a provision in that order that says, I mean, obviously it's sort of implied, but just to make it explicit, defendant's presence at the property during 21 days will not constitute a violation of the PPO.
Yes. You please provide that to her in her attempt.
I'll get that order sent to the court today. Thank you, Your Honor.
They're on the first floor and the second floor. Are you aware of that?
I have heard something to that effect. I think Ms. Evans maybe disputes whether the plaintiff is in fact living in the property or not. I don't know that we need to get into that, but
Yeah, so please put that in the PPO, just so Ms. Evans, doesn't go to jail. I'm not comfortable about this case, and
nor am I, Your Honor.
I feel like this is going to. If they're living in the same property, they're probably shouting and can hear each other over Zoom through the floor. So let's try to make this, yeah. So Ms. Walls, please provide access to Ms. Evans. And I can't tell you to not be at home, but the court will keep their eye on this case, and please don't violate the order of the court.
Thank you, Your Honor.
Thank you. All right. Attorney Sabree.
Good morning, Your Honor. We're ready for a recall on the case ending in 6627, Lawton versus Deja Beckham and all other occupants.
On case 23346627. This is Develop Detroit Lawton versus Deja Beckham and all occupants.
Good afternoon, Your Honor. Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff.
Thank you. Let's see, is Deja Beckham here?
No, she's not. I'm here on her behalf. I'm an occupant in the dwelling.
All right, can you state your name, sir?
Surround Pod.
All right, thank you, Mr. Powell. All right. The party's able to work out a resolution.
Yes, Your Honor, we were able to come to terms for a consent judgment against all other occupants, wherein the defendants agreed to vacate and provide keys on or before June 16th of 2023. Given that Ms. Beckham has not appeared and she is not represented, we would just request that the named occupant be a default and the consent judgment be as to all other occupants.
There is a default judgment enter as to the named party of Deja Beckham and a consent judgment to all occupants.
Yes.
With a June, well, a hearing judgment.
Yeah, hearing judgment I think would be smoother, considering that Mr. Powell is not a named occupant, so a hearing judgment would be preferable.
All occupants must vacate by June 16th. 2023, or a writ may issue. Did I miss anything?
No, Your Honor.
All right.
Oh, I'm sorry, my apologies, with 4B checked.
Okay. Okay.
And Your Honor, is it possible to be put in a breakout room with Mr. Belk, Devin Belk? I believe he'd requested to speak with someone from Attorney Gann's office earlier.
Absolutely.
Your Honor, could the court call my case with Ms. Sprague before she leaves for the breakout room? I've got 4 other matters pending in front of Judge Jacquet.
Attorney Sprague, you ready to go?
Sure.
Okay. Would you all need to go in the breakout room, set?
I don't think so, Your Honor.
Okay. All right, let's see. My last case was correct. I tried to wing it. See how that turned out. Calling case number 23346628. Detroit versus Maurice Thompson.
Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff.
Good afternoon, Your Honor. Marie Reimers, P82841, appearing on behalf of both tenant defendants, Ms. Courtney Pedersen and Mr. Maurice Thompson.
All right, thank you. And Mr. Peterson?
Ms. Peterson.
Excuse me.
Ms. Peterson, Mr. Thompson.
All right, can you state your name for the record, Ms. Peterson?
Courtney Peterson.
All right, thank you.
Maurice
All right.
Thompson. Maurice Thompson.
Thank you, Mr. Thompson. All right, we're party. Okay, so this is a complaint to recover possession of properties. It's the termination of tenancy case. There's no amount to redeem. How much time is needed to vacate?
Well, Your Honor, we're actually asking the court to set this for a trial today. Defendants allege under MCL 600.5720 that this action is in retaliation for them asserting their rights in a prior action. That prior action was 22-382019 LT in front of Judge Jacquet. That was a non-payment of rent action that was scheduled to go to trial. When the defendants refused plaintiff's settlement offer, they were told, if you refuse the settlement offer, we will bring a termination case. Clearly in retaliation, clearly unlawful. We'd ask the court to set a trial to find that.
All right, do you plan on briefing this issue? And hold on, I'll allow for a response.
Certainly, to clarify, what we had shared with Attorney Reimers is given that there has not been payment on this and there has been a balance on this account for several years at this point, we were hopeful that a resolution could be made with a non-payment case. Given that there was no resolution granted, we did indicate that a termination of tenancy would be filed for a complaint to recover possession. Given that there was repeated non-payment of rent that did violate the terms of the lease, it's not retaliatory in order to require the defendant to conform with the terms of the lease.
Your Honor, a non-payment of rent action was brought. My clients alleged that they did not owe rent due to the condition of the property. The case was set for trial. We were in heavy settlement negotiations when I was told, if your clients do not accept the settlement negotiation, we will bring a termination case. That is almost black letter MCL 600.5720 retaliation. They asserted their rights and they were met with a notice to quit. I'd love to brief it.
Your Honor, we dismissed the case for the non-payment and we filed for a termination of tenancy. We'll look forward to the adjournment date for the trial.
Okay. And I'll set a date. It's like parties are ready. How much time is needed? I want to keep it close to the date.
Your Honor, I think that the court can decide this by motion for summary disposition. So I would ask for probably 4 weeks, with that being like the final motion trial date.
All right, motion. So let's see. 21 and 20, yeah. 30 days is tight, but you all know each other's arguments anyway, so. Well, at least you know defense argument. 30 days, any objection? 30 days?
No, Your Honor.
Excuse me.
Ms. Peterson, we'll talk after court.
Okay, can you point out that they did receive the 3,000?
Ms. Peterson, please don't talk. Thank you.
All right.
About 60. It's not on the 16th, we just went straight to the first. I have June 21st. Does that work for parties?
That will work with our schedule. Thank you, Your Honor.
So
I'm sorry, Your Honor, can you say that again?
June 21st at 10:30. All right, our parties will be ready to argue their motions. Well, you'll be filing a motion for summary and parties will be ready to argue and defend.
Yes, Your Honor.
Okay, all right. Well, I see you all back at the showdown on June 21st at 10:30 a.m. If parties are able to resolve this issue before, please notify the court, and we'll be in person at that time too. So keep that in mind.
Thank you, Your Honor.
Thank you.
You're welcome.
Your Honor, could I go into a breakout room with Mr. Belk now?
Absolutely.
Thank you.
All right, counselors. Keep it in order.
Hi, Judge. This is Artisha Dunbar. I was recently in the breakout room with one of the attorneys. We had came to agreement. I don't know if he left or not, but I got in when all the previous case was before this one.
Mr. Belt, room 4. Attorney Sprague, room 4. And what's your case number, ma'am?
One moment. Case 233465990, I believe.
Arkeisha Dunbar.
Yes.
All right, would you like to speak to Attorney Horka or let's hold on. You're with Attorney Horka. So if parties, did you finish speaking to Ms. Dunbar on 590?
I did. We have a resolution, Your Honor.
All right, let's just call it right now. She's on the phone. Then Attorney Spaniolo, you're next.
Thank
you. And then Attorney Wyrack, you're after. You're third in the queue. All right. Calling case number 233465990. This is Core International Group versus Arkeisha Dunbar.
Good afternoon, Joe Horka, P75969, appearing for the plaintiff.
Thank you. Ms. Dunbar, can you state your name for the record?
Yes, Arkeisha Dunbar.
All right, Arkeisha.
There's a date and time for a subsequent hearing on a termination of tenancy case. The parties would like to submit a consent judgment, just indicating a June 16th move-out date.
All right. You are agreeing to vacate the premises by June 16th, 2023. After that date, a writ can issue. This is a consent judgment. You're not represented by counsel. So Michigan Court Rule 4.201I applies. In a sense where if a motion to set this aside, we would hear it if it has some merit to it. But that's just a right that you have because you're unrepresented by counsel. So do you consent to this agreement to vacate by June 16th?
Yes.
All right, do you have any questions?
No.
Does Mr. Horka have permission to sign your name on the consent judgment?
Yes, sir.
Okay, I'm satisfied. Good luck, Ms. Dunbar.
Thank you.
You have a great day.
Have a
Thank
great
you.
day.
As promised. You're welcome. You're welcome. She thanks you too, Mr. Horka.
Hello, Your Honor. I'm back from the breakout room. I met with counsel and I believe I'm ready.
Fantastic. All right. You're down the queue. You can put your hand up if you like digitally, and I'll try to get you in the order of operations here. Counsel, is this for case number ending in 536? Or did we already adjourn? Do you have another matter? Oh, this is 604, correct?
6604, Your Honor. Yes, that other one we adjourned to the 30th.
Tense hearings today. Calling case number 233466604. This is Evernest LLC versus Alfonso Thomas and all occupants.
Thank you, Judge. Good afternoon. Attorney Paul Spaniolo, P72366, on behalf of the plaintiff in this matter.
Thank you. Alfonso Thomas?
Yes, I'm here, Alfonso Thomas.
Thank you. Good morning. Well, good afternoon. All right, counsel, I'll let you lead the way.
So, Your Honor, I had the pleasure of meeting and pre-trying the matter with Mr. Thomas, and it seems we have a resolution. I'll put that on the record, Mr. Thomas. If there's anything I inadvertently omit or misrepresent, please let the court know. Your Honor, we're going to enter into a consent order for conditional dismissal. The amount of rent and late fees was $715. Court cost $168.00 for a total, if my arithmetic serves me correct, $883.00. This is to be paid on or before May 31st. We discussed, I told him about 4B and what that means. We're going to check 4B that I don't have to give him notice. I did not tell him, and I'll tell him now, that a partial payment will not prevent an issuance of an order of eviction, that the full amount needs to be paid on or before that date of May 31st. And then I did explain MCR 4.201, that he has an opportunity within 3 days to review this with counsel because he's not represented, to ask the court to set it aside. I have received his email in the breakout room. I forwarded him a copy, and I did ask him, and he said I could sign his name with permission, but I asked him to respond in the email. He had the email probably for, I don't know, this time that we've been on, to review the CD and give me approval to submit it.
All right, Mr. Thomas, are you in agreement with these terms?
Yes.
Okay, well, the court, you've addressed everything, counselor, so the court will approve and enter the conditional dismissal. Good luck, Mr. Thomas, 883 by 5/31/23.
Thank you, Judge. And Mr. Thomas, please respond to that email if you don't mind.
No problem.
Thank you, sir. Nice meeting you. Be well.
Thank you, counselor.
Thank you, Judge. Have a great day.
All right, you too. All right, Attorney Wyrock, and then
Ready, Your Honor.
this on 586 and
Yes.
calling case number 23346586. This is 8590 Littlefield LLC versus Deanna Malone.
Good afternoon, Your Honor. Diane Wyrock on behalf of plaintiff P59773. This is a termination action set on 8590 Littlefield in Detroit.
All right, thank you. And is Ms. Malone here? Is there anyone from 8590 Littlefield present? It appears that defendants failed to appear not once, but twice. Counselor, do you have any requests for the court?
Yes, I request a default judgment of possession with a move-out date of 10 days.
All right, default judgment is granted. Parties must vacate. Ms. Malone and other occupants must vacate from the Littlefield address on May 26th, or writ can issue.
Thank you very much, Your Honor.
Excuse me, Judge. Deanna Malone, she's.
Hold on, Ms. Wyrock.
She just called on the line. She's.
Ms. Malone just called on the line.
So I guess the Zoom is not responding. She
said the Zoom is not responding. So let's do it this way.
Can you put her in a breakout room with me?
She called the court. I could.
I mean, she was supposed to be here at 10 and she's never appeared until now.
She's here, Ms. Wyrock. I'm not about to default her. I'm not about to default her, okay? This is Zoom, not in person. Half the people on here don't even know how to work Zoom. So I understand the technological issues that come with this. We'll be back in person June 5th. Everything will be. Ask her, does she agree to a move out date? May 26th.
The judge said you agree to a move out date of May 26th. Hold on one second. Judge, I'm not gonna. Okay, say that again.
So he said 30 days, I mean 30 days.
You all need to talk. She needs to talk to Attorney Wyrock. Get her number, I'll give it to Attorney Wyrock. Okay. Ms. Malone, you're. Okay. Get her number. Attorney Wyrock, can you call Ms. Malone?
I'd be glad to, the number.
I'll send it to you in the chat. Maybe something could be worked out fairly efficiently.
Excuse me, Your Honor.
You know. Mr. Biddles.
Yes, I came to agreement with the attorney.
All right, with the attorney, okay, who's your attorney?
No, I don't have an attorney. It was.
Your Honor, Mr. Biddles was the landlord in case 599, and we have reached resolution in that case.
Okay, I'll call Mr. Horkin and I'll call you on next. You're with that case, counsel?
Yes, I assisted the parties in negotiating the conditional dismissal.
Okay, all right. Thank you for letting me know. I'll call you all next. Mr.
Your
Horkin.
Honor, should I call her and then report back to you?
Yes, please.
Thank you.
You're welcome.
It should have a handful of cases ready.
Okay.
Resolution 594.
That resolution on 594. Let's call your resolutions and then I'll call your defaults after I get the other resolutions. So free up everybody. So 594, calling case number 2334-6594. This is Investors Property versus Walker.
Good afternoon, Joe Horka, P75969 on behalf of the plaintiff.
Thank you. And, Mr. Netta Walker, are you present?
Yes,
All right, can you state your name for the record?
Danetta Walker.
Thank you, Ms. Walker. Attorney Horker, can you put the terms on the record?
And Your Honor, this is a non-payment of rent case. The defendant owes $15,338. Planning on moving from the property, but it'll remain as a non-payment pay or move by June the 16th. By way of consent judgment.
Okay, pay or vacate by June 16th?
Yes, Your Honor.
Is this what you're agreeing to, Ms. Walker?
Yes,
All right. And MCR 4.201I says that as an unrepresented person, you can file a motion within 3 days if you decide to back out of this agreement. But whatever you file, you have to have a rational basis to back out of the agreement. But you do have that right within the court rules. Parties do consent. We aren't in court, we're distant. Mr. Horker's in a different place than you, Ms. Walker. I'm assuming, does he have permission to sign your name?
yes,
On the judgment, okay. And all right, the court is satisfied. Did I miss anything, Mr. Horker?
No, Your Honor. Thank you.
Well, that's 594. What else is ready?
582 at 9:30, just looking for an adjournment with Mr. Tate.
At 582?
Yes.
Yeah, 2 582s. All right, calling case number 22395582, Logical PM versus Tiana Jackson.
Good afternoon, Joe Horka, P75969, appearing for the plaintiff.
Good afternoon, Your Honor. Attorney Sean Tate, P57767, with Lakeshore Legal Aid, representing Ms. Jackson. Ms. Jackson, can you please place your name on the record?
My name is Tiana Jackson.
Thank you, Ms. Jackson.
Yeah, no, this is a non-payment of rent case. There's a subsidy involved. Repairs were once an issue, but that's been resolved. We believe that the balance may be paid by Inkster Housing Commission and resolve this case on its own, but I'd like an adjournment to investigate that before we move to dismiss.
That is correct, Your Honor.
Okay, all right. It seems like we're making some progress, so I don't mind you all coming in court one more time to get Ms. Jackson where she needs to be. So is the end of how much time do you need?
If we can keep it on Zoom, I would prefer the end of the month, but it's okay if it spills over in person.
My only issue is that after June 5th, the cases aren't already in the system for some of these dates. So I don't know what the docket's gonna be like. I know May 30th and 31st is pretty doable. So
That works for me.
we think, Mr. Tate, 30th and
May
31st.
May 31st may work
Okay, and if it doesn't, you know, we'll figure it out at that point, okay?
because, okay. If it works out, if it works out, we can submit a dismissal.
Okay, all right, so 10 a.m., May 31st.
Tiana. Okay, thank you.
10
Can I
a.m.
have-
Tiana. Oh, you thought I was saying your name?
Oh, yes.
Can I have host privileges, Your Honor, so I can speak with Ms. Jackson in the breakout room?
Absolutely. All right, I'll see you all back at 10 a.m.
Thank you.
May 31st. All right, you're welcome. All right, Ms. Lab Bench, I know that is not your name.
Anthony Johnson. Anthony Johnson, Your Honor.
Anthony Johnson. Mr. Johnson, who was, I know Mr. Martinez stepped in. And what case are you on?
So 233 for 6624.
Okay, well, are you all ready to be called?
No, Your Honor, we're asking for an adjournment.
Okay, hold on one second. And Attorney Gandy, all right. Let me call Clifford Biddles and then I'll call you all next.
Okay.
Calling case number 233465999 Clifford Biddles versus all occupants.
Yes.
Yes, please state your name for the record.
Oh, my name is Clifford Biddles.
Thank you, Mr. Biddles. And does anyone reside at 3777 Clements?
Yes, sir.
All
Mr.
right,
Wilcox.
all right, what's your first name?
Daryl.
Okay, thank you, Mr. Wilcoxon. And I see you've been present at both hearings. And you have counsel, is that correct?
Yes.
Can you state your name for the record, counsel?
Good morning, Your Honor. Nicole Van Blarkum, P86616 with Lakeshore Legal Aid on behalf of the defendant.
Good afternoon. All right, were parties able to work out an agreement or frame some type of resolution?
We were, Your Honor. We reached a conditional dismissal with a move-out date of June 16th.
2023, is it as straightforward as that? Is 4B checked?
Yes.
Okay, and I'll just do it real quick. 4B means that a judgment and a writ of eviction can be executed at the same time, Mr. Wilcox. So right now, as it stands, your name is not on this case. It was filed to all occupants. Even though you appear, there has been no motion to add your name to the case, and we don't see a need to add your name to this judgment. But a conditional dismissal has been agreed upon through your counsel and your landlord. So if you vacate by June 16th, case is dismissed. If you don't vacate, judgment goes and writ of eviction is filed. So both of those will be filed at the same time and the eviction process will get started. So are there any questions?
No, sir.
All right, do you give your attorney permission to sign your name?
Yes.
All right. Did I miss anything?
I don't think so, Your Honor. I'm going to get that drafted and sent to Mr. Biddles for his review today, and then I'll get it submitted to the court this afternoon.
Thank you. I know Lakeshore is lean today, so we appreciate the assistance.
I have a quick question, Your Honor.
Sure. Mr. Biddles?
I was just like, would she provide Mr. Darrell with my phone number so he could let me know if he gone on the 16th and I could just meet him over there to change the locks or whatever. That way I won't have to be, sitting around there pulling up the next day to see it. That's all.
I can do that.
That's possible.
Okay, and Mr. Wilcoxon, you heard that as well.
Yes.
So let's just stay in good communication, and counsel, if you could help exchange numbers, stay in communication so he doesn't have to pull up and guess when you vacated, and you all can both plan accordingly and coordinate. So, all right, good
Yes, I
luck.
will let him know when I vacate, and I'll take his number and let him know.
I appreciate it.
All right, sounds like you all seeing eye to eye on this one, and thank you for your patience, Mr. Biddles. Thank you for your advocacy, counsel. This case is concluded. You all are free to go.
All righty, have a good day.
All right, sir, have a good day. Thank you.
Well,
Bye-bye.
all right. Frankie?
Hello, Judge.
Yes, ma'am. All right, Mr. Hort, yes, you said hello, but I didn't hear anything after.
This is Tony Davis. I'm trying to see how long it's gonna be before I get everything set.
Attorney Hork, are you ready on 631?
Yes.
Okay, let's call it. Calling case number 2334661, Investors Property Management versus Kimo Neal and Tanae Davis.
Good afternoon, Joe Horka, P75969 on behalf of the plaintiff.
Ms. Davis,
I'm sorry.
can you state your name
Yes,
for the record?
I'm here. Tony Davis.
Tanae Davis. All right, thank you.
Ms. Davis and I met in a breakout room earlier. We agreed that the balance owed is $5,385. That figure does include the court costs that are due. She can either pay that amount by June 16th or vacate by that same date. We'd like to submit a consent judgment with those terms.
All right, and as an unrepresented party, you have a right to file a motion within 3 days under Michigan Court Rule 4.201I. Also, this is a consent judgment, so Mr. Horka may sign your name on the judgment. Do you give him permission to sign your name instead of the alternative of sending it to you to sign it and sending it back to him?
Yes.
Okay, any questions?
You went kind of fast with how I filed a motion, and I'm at work. I'm literally like, I don't have any paper, pen, or nothing. Is there a way you could send me the information to how I can file a motion?
It's actually, it's MCR. I don't see how I would send it to you, but it's more of a motion thing where if you thought that this wasn't a good agreement, then you can file it. It's 4.201I. It's
okay.
Yeah, 4.201I. If you want to look at the rule, you're more than welcome. But it's more of an emergency thing. If you actually felt like disagreement, you go home and say, I shouldn't have done this, then you would rush up to the court and get that filed. But
okay.
But you do agree. I just had to let you know of your rights. So you do agree 5385 or vacate by June 16th, 2023.
I don't agree, but how can I go about that? Because my worker was supposed to help out as far as my rent, and that June 16th, I gotta see. I don't know. I don't want to agree to something and I'm not sure about. This is the reason I'm going to court through as far as my worker. I had to go to court first to send him the information to get approved, I'm guessing.
Is this through SDR?
Yes.
Yeah, well, SCR is gonna need a judgment. So I can do a judgment by hearing.
Okay, please, because that was my whole reason of coming to court.
We'll convert it as a judgment by hearing where $5,385 has to be paid by June 16th.
That works, Your Honor.
Okay.
All right, good luck. Make sure you take it straight to your, I will try to get this back to you as soon as possible so you can get to processing it with SCR.
Okay, thank you. I appreciate it, and I'll take it straight there as soon as I receive it.
Okay.
Star on hers. Yes, Judge.
All right, Mr. Horka, I'll call the rest of yours since you're here. I know you have places. It's 592. Is Philip Henderson here?
Am I all set, Judge? I'm sorry, this is Tony.
Yeah, you're free. You're all set.
Okay, thank you. Have a good one.
You're welcome. Philip Henderson. Calling case number 2-334-6592, Investors Property Management versus Philip Henderson.
Good afternoon, Your Honor. Joe Horka, P75969, appearing for the plaintiff.
Thank you. Is Philip Henderson here?
And if Mr. Henderson has failed to appear, I would request a default judgment. This is a non-payment of rent case for possession only. The total due, including the court costs, is $6,215.
$6,215. Default judgment is granted. It's possession only. $6,215 must be paid by May 26, 2023, or writ may issue. Mr. Betancourt, I see you on here. I'll call you after Attorney Horka's cases. All right. Just want to give you a heads up. You've been here all day. All right. It's 572. Ready? Does anyone live on Hayden? 18541 Hayden. Calling case number 2-334-6572, Alicia Coleman versus occupants at 18451 Hayden Street.
Good afternoon, Joe Horka, P75969, appearing for the plaintiff.
Thank you, Mr. Horka. Alicia Coleman, I'm sorry, Hayden. Does anyone reside? All occupants at 18451 Hayden. This is a complaint for the recovery of possession of property. Defendants have failed to appear. Are you requesting a default judgment, counsel?
Yes, please, Your Honor.
Default judgment is granted. Defendants must vacate by May 26th or writ may issue. $572. All right. Is Natasha Lopez, did we do that?
We already did that one.
And are the Thomases, Brandon and Brenna, 6360?
I think we have a resolution on that, Judge.
What about Siobhan Murphy?
On Murphy is a dismissal.
Calling case number 2-334-6611, DG Residential Sales versus Siobhan Murphy and all occupants.
Good afternoon, Joe Horka, P75969, appearing for the plaintiff and moving to dismiss.
This case is dismissed without prejudice. Thank you. All right, and what about Annie Bridges?
Hi, Jordan. This is Samantha with Steve Gann's office. Is this
615-6615. Annie Bridges here. Calling case number 2-334-6615, Woodbridge Senior Village versus Annie Bridges.
Good afternoon, Joe Horka, P75969, appearing for the plaintiff.
Thank you. Is Annie Bridges here? Annie Bridges. Ms. Bridges. Anyone on the lodge? 3521 Lodge. All right, counsel.
Your Honor, I don't have this particular one on my list. Can I submit a default if necessary and a dismissal otherwise?
Yes, I'll allow you to do that. So defendant failed to appear. Defendant failed to appear. Default judgment is granted. Defendant must vacate by May 26, 2023, or writ will issue.
Mind if I grab that case number from you?
Mr. Harkin, what'd you say?
Do you mind if I grab that case number from you?
That is 2334-6615.
Thank you.
I just put. All right. And Mr. Harkin, do you have? What about Sharita Rhodes? (633).
I haven't made any contact with that person today.
Is that person here? Is Sharita Rhodes here? Some of you all been here all morning. Calling case number 2334-6633, Cessna One LLC versus Sharita Rhodes.
Good afternoon, Joe Horka, P75969, appearing for the plaintiff.
All right, thank you. Does anyone live on Dickerson? 2931 Dickerson.
Your Honor, this is a termination and tenancy case. I would seek a default judgment of possession.
Dickerson is failed to appear. No one is answered to call the court for residing at 5931. There's nobody in the breakout rooms. Default judgment is granted. This is a termination of tenancy. Defendants must vacate by May 26, 2023, or writ may issue.
And then 360, I think we have a proposed resolution.
Okay, 360. On case number 2334-6360, NHL Property Management versus Brendan Thomas.
Good afternoon, Joe Horka, P75969, appearing for the plaintiff.
Thank you. Brandon Thomas.
Yes, this is Brandon Thomas.
Thank you, Mr. Thomas. Resolution. Go ahead.
We had an initial conversation. I reached out to my client to see if they would approve an agreement. I was unable to get Ms. Thomas back in the breakout room thereafter, but as long as things are what we discussed, I think we may have a resolution. The total is $2,415. That figure includes court costs. There is $900 held in escrow from a prior Sarah case that Ms. Thomas has agreed to release to the Cox firm. I will need permission from her to sign a stipulated order to that effect. That'll leave her at $1515. She's agreed to pay her upcoming rent plus $500 each month until that account is current.
Rent plus $500 each month plus $900 release in escrow.
Yes.
And the total is 2415 of rent owed.
Yes.
Okay. All right. Court will accept that. Is that a conditional dismissal?
Yes, we can do this as a conditional dismissal with box 4B checked, but I didn't explain what that means to Ms. Thomas.
Okay, Ms. Thomas, the conditional dismissal, this case will be dismissed if you fulfill these terms. If not, a judgment can be entered as well as a writ of eviction at the same time. Okay? Or
Okay,
gas leak. Go ahead. Ms. Thomas, did you have a question?
No, go ahead.
Okay, were the gas leaks fixed?
No, Your Honor.
Okay. Let's make sure we're being safe. Call DTE DTE will come out if it's a gas leak. So don't sit in the house with gas.
Your Honor, I did call DTE. They did come out and they fixed them, but they also told me to contact the property management company as well, which I have contacted them too as well. They just haven't sent anyone out from the management company yet.
Okay. Keep contacting them. Go ahead.
I'm sorry, Your Honor. Well, I was just going to say, let's add an additional term that plaintiff must inspect and repair as needed within 14 days any gas leaks.
Okay. All right. We'll enter that as a additional condition. Thank you, Attorney Parker. Try to stay on it. Try to stay on it, whether they respond, and call them every day.
Okay, I will.
All right. I think that concludes your docket.
Thank you, Your Honor.
You're welcome. Mr. Betancourt.
Quick question, Your Honor. Who do I contact to release those funds to the property management? Sarah?
So, Ms. Thomas, I was actually going to ask for your permission to sign your name, not only to the conditional dismissal, which has the payment plan and the repair order, but we'll also submit another order to the other judge that says we have the permission to get the escrow back to us. Do I have your permission to sign both those documents?
Yes, sir.
All right, the court is satisfied with that. All right. Thank you, Mr. Harper. And thank you, Ms. Thomas.
All right, thank you. Have a good day.
Thank you, Betancourt.
Hello.
Hello?
Hello. Yeah.
Yes, calling case number 233465550, Frankie Betancourt versus all occupants at the address of 6121 Horatio. May I have appearances? All right. I can't hear you, Mr. Betancourt. Can you state your name, please?
Frankie Betancourt.
All right, thank you. Is anyone here that lives at 6121 Horatio? Defendant has failed to appear. Are you requesting a default judgment? Mr. Betancourt, are you requesting a default judgment?
Yes.
All right, default judgment is granted. Defendants must vacate by May 26, 2023, or a writ may issue anytime after. Mr. Betancourt, please submit something to the court. Please submit a judgment to the court and we'll sign it, okay?
Okay, is that a writ of eviction? Or?
No, you get a writ of eviction after the May 26th date. You have to submit it, but you'll be eligible after the move out time, 10 days.
Okay, so what am I supposed to submit to the court after the 26th?
You have to go on too. I can't give you legal advice. There are a lot of qualified attorneys in here, and they'll be willing to assist you with that. Probably for a small price, but or they may do it. I don't know, but there's some attorneys in here. I just can't offer legal advice. But it will be after that move out day.
It was, you said May 26th?
May 26, 2023. Yes, sir.
Okay.
All right, good luck. Attorney Wyrock.
Yes, Your Honor, I spoke with, on 6586, I spoke with the defendant, and she authorized me to put our settlement on the record.
Okay, we're calling case number 2334-6586. This is 8590 Littlefield LLC versus Deanna Malone.
Yes, Diane Wyrock on behalf of plaintiff P59773. This is regarding 8590 Littlefield in Detroit. We agreed upon a hearing judgment dismissing Ms. Malone from the case and taking the judgment against all occupants, and then giving her 30 days to June 16th to move.
All right, sounds like a agreeable deal right there. All right, counsel, I will state on the record that we did initially enter a default, but Ms. Malone entered the court. She contacted the court. She was unable to join by Zoom. You actually reached out to her. You all were able to work out an agreement, and she's unable to join on the record. However, these are the terms that were set forth in that agreement, and you've recited them for the court today. Is that correct?
That is correct. And she also indicated that she had been on Zoom since 9:30, but she could hear us, but you couldn't hear her. So I believe she'd been sitting there all that time.
I believe so, and everyone doesn't have the same technological abilities. So that's fine. I'm glad you're able to work it out.
Thank you. I'll submit that judgment today.
All right, thank you.
Thank you.
You're welcome. Attorney Sprague and Attorney Martinez.
Good afternoon, Your Honor. We are ready. I am ready on a recall for Mr. Belk.
All right, is this a resolution?
It is a resolution, Your Honor. We just would like to put the terms for a conditional dismissal on the record.
Okay.
And it's a case ending in 6629.
On case number, we calling 2334-6629 Chesterfield Apartments versus Devon Belk.
Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff.
Right, thank you. And
Devon Belk.
thank you, Mr. Belk. Counsel, could you put those terms on the record?
Yes, Your Honor, we do show that there is currently due and owing a total of $1,678. Mr. Belk has agreed to provide payment of his June rent as well as any applicable late fee on or before June 5th. Additionally, he will provide a payment of $500 on or before June 12th, another payment of $500 on or before June 19th, and the final payment of $628 on or before June 26th. That is with box 4B and box 7 checked.
All right, is this your understanding of the agreement, Mr. Belk?
Yes.
All right, well, the court is satisfied. Good luck. This is under the form of a conditional dismissal, counsel?
Yes, Your Honor. And Mr. Belk did provide, if he could confirm that he's providing an authorization for me to sign on his behalf.
Yes, that's fine.
All right, the court is satisfied. Good luck, Mr. Belk. So 1678 is broken up. You still owe June rent by June 5th, and 500 by the 12th of June, 500 by the 19th, and the balance of 628 to finish it off by the 26th. So basically,
my apologies. It should be 678 for that last one. That was a misspeak on my part. That final payment is 678 on June 26th.
678 instead of 628, Mr. Belk.
Yes, that's
all right. Okay, all right, well, good luck. Sounds like you all have it under control and have a great day. Thank you for your patience.
All right, thank you.
Your
Have a
Honor. We are also ready on a recall for 6620.
Calling case number 233466620. This is Marwood Marston 2020 LLC versus Miracle Homes Vanover.
Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff.
And Kyle Keenan, P86413, Lakeshore Legal Aid, appearing on behalf of Ms. Hill. Ms. Hill, could you please state your name for the record?
Jalissa Hill.
Alyssa Hill, good afternoon. All right, were parties able to work something out?
Yes, Your Honor, we have come to terms for a conditional dismissal. Currently, there is due and owing past due rent in the amount of $4,078, other fees of $25, and court costs of $160 for a total due of possession of $4,263. Ms. Hill has agreed and on behalf of herself as well as all other occupants to a pay or move date of June 1st with the keys returned, as well as box 4B and 7 checked.
That is correct, Your Honor. I will be filing my appearance and drafting this conditional dismissal, getting signatures and submitting it to the court on Ms. Hill's behalf.
All right, the court is satisfied. Thank you, counsel. And Ms. Hill, did you give Mr. Keenan consent to sign your name?
Yes, I do.
All right, thank you. You all have a great day. Well,
You too. Thank you.
Thank you
Your
much.
Honor.
Thank you, Counselor.
Thank you.
okay, let's see. Is Michael Belcher, are parties ready on Michael Belcher?
I see a Belcher on the screen, but we have not had a chance to speak. I don't know if legal aid has spoken with him.
Yeah, I'm here. I'd like to speak.
Okay.
And Mr. Martinez, I do have a meeting, so let's call your case. I believe, is this an adjournment?
I haven't had the opportunity to ask Ms. Sprague if she was agreeable to an adjournment yet. Mr. Johnson would like an adjournment, so we had time to speak on his case. If Ms. Sprague isn't agreeable to an adjournment, I asked we be placed in a breakout room after her case is handled.
We would be hopeful for a resolution if Mr. Martinez would like to speak in a breakout room.
Okay, I have a meeting that I have to go to. So I tried my hardest to get everything done before 1. I didn't stop at 12:30 like usual. I pumped it through 1 o'clock. We don't have an afternoon docket, but we have 1, 2, 3, 4 cases that still exist. So, no, actually, we only have, we have 4 cases left. If you all
I believe
want-
Your Honor, I believe I have 3 of those. Is it possible to have a default called on the Xavier Lewis before you leave?
On case number 233466626, this is Marwood Marston 2020 versus Xavier Lewis and all occupants.
Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff.
All right, is Xavier Lewis here? Anyone on East Marston here? All right, defendant failed to appear at the first hearing. It appears that Mr. Lewis and all occupants didn't appear today. Counsel, do you have any requests?
Yes, Your Honor, we would respectfully request a default judgment in the amount of $3,150 for past due rent, $100 for other fees, and $160 for court costs, for a total due and owing of $3,410 with a 10-day vacate date.
All right, the math is correct. And parties must vacate by May 26, 2023, or writ may issue. All right, thank you. All right, maybe you all can work this out. I mean, I'll be back. I mean, we're almost there, so.
Your Honor, I don't have any controls because I'm not a legal aid. Is it possible that you could provide controls so I could go into a breakout room with Mr. Martinez as well as Mr. Belcher or Ms. Belcher?
And Attorney Sprague, I give out the control, so it's not because they're legal aid. I just miss. I
Oh,
over.
okay. My apologies.
I give all the attorneys or plaintiffs control so that, you can traverse through this great issue, bro, we're in. All right, Dexter McElrath, okay. We adjourned that, didn't we?
Yep.
All right, so you have the last two cases. I know this meeting won't go past 1:30, but my staff wants a break. Now, Madam Court Reporter.
Yes, Your Honor.
I don't have an afternoon, so I want to go into this meeting and then just come out in 30 minutes and then we'll be done. Is that okay? That wouldn't that would chop up your lunch.
Okay.
So it's up to you. I can
Okay.
come back, we can come back at 2 or 1:30 and get it knocked out. It's up to you.
We can come back at 1:30. Well, I don't know how the clerk feel. 1:30, Curry?
1:30 for me.
2 o'clock.
Okay, all right. Okay. All right, so we're not gonna shut anything down. I need to go run into this meeting so we know how we'll be proceeding on the 5th and beyond. And you all will have time to talk in the meantime. And then, so it's 563 with Daryl Cone. Oh, no. We're gonna call this matter right now. Calling case number 2334-6563. This is Daryl Cone versus Danielle Matthews, Freddie Matthews.
Danielle Matthews here.
Oh, parties are here. What is this case? All right, and Daryl Cone, were parties able to work out an agreement?
No, never had a chance to speak with anybody.
All right, I'm gonna put you all in the breakout room as well. And then you all talk for this 30 minutes, and then when I get back, I'll call this case. We only have 3 cases left, and unfortunately, you're one of the 3. Been trying to get as many people out of here as possible. But you're the last 3, and at this point, it's already 1 o'clock, so. Room 20. You've been looking at this screen the entire time. All right. Legs. If I can come back earlier, I will.
Mr. Belcher or Miss Belcher, if you can please accept the join. Mr. Johnson? Mr. Johnson? If you can, please accept the join to join the breakout room. Thank you.
All right, thank you for your patience, everyone. So, you all, when we're done with the docket, if you have any questions about how court will proceed after the 5th, you stayed this long, so you might as well get the information. So, thank you for your patience again. All right, I'm assuming all of you all are ready. Let's get you all out of here. Some of you all been here since 9 o'clock. I hate to remind you of it. Let's knock it out. Ms. Milton, I don't have an afternoon docket. Are you checking in for your afternoon case?
No, they just sent me over here from the last courtroom. They said that since this is my second one, I'm supposed to be over here, but I didn't think that I was supposed to be, but I can't find my original piece of paper. But when I went to the courtroom that I was originally in, they told me that they didn't have me in the system. So I've kind of been bouncing around for the last 40 minutes.
All right, sit tight.
I have been trying to look up my case number, but the website, it keeps on saying the pages are under maintenance, and I'm trying to find the piece of paper.
Our clerk, we have cases. We have 4 cases, and after these cases are called, I'll take care of you. Because there's some people who've been waiting since 8:30. I just had to come back from a meeting, so you're 5th in the queue. All right.
Just wait on the Zoom.
Yeah, just wait on the Zoom so we figure it out for you. Okay.
Thank you so much.
Is that the spelling of your name?
On the Zoom, is that this the correct spelling?
Yeah.
Yes, Anissa Milton, ANISAH, MILTON.
All right. When my clerk gets back to the computer, he's looking for some files. When he comes back to the computer, he'll type it in.
Okay, thank you so much.
All right. Who would like to start?
We're ready, Your Honor. On
Okay.
the Anthony Johnson or the Michael Belcher one.
Johnson and then Belcher. Let's see. We'll go in order. 24 first. 2334-6624. This is Marwood Marston 2020 Limited versus Anthony Johnson and all occupants on East Marston.
Good afternoon, Your Honor. Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff.
Thank you. Thank you.
Good morning, or good afternoon, Your Honor. James Martinez, P86604 in a advice-only capacity.
Thank you. And Mr. Johnson?
Yes.
Mr. Johnson, can you state your name again? I think we lost.
Anthony Johnson.
All right. And I'm going to stop your video because it looks like you're losing a little bit of bandwidth there. So I can still hear you and I know you're here. And we heard you, Mr. Johnson. Thank you for being patient. Parties, what do we have?
Your Honor, we were unable to come to terms for an agreement. There is currently due and owing over $13,000 to my client. So we would request a judgment at this time. It does not appear that Mr. Johnson is alleging that the amounts are due. His allegations seem to stem from, well, I'll let Mr. Martinez.
Oh, yeah, Your Honor. Mr. Johnson indicated to me that he wanted an adjournment to further investigate the matter. I informed Mr. Johnson that he was not entitled to an adjournment today. It seems as if though there is some dispute of how Sarah was paid out. I didn't see anything on my end that indicates that there was any meritorious defense there. That's where I'm.
So there was no. Understood.
Your Honor, there is documentation to state that why the Sarah it was changed. It was changed based on a conversation from the landlord at Marwood. I mean, the property management company on behalf of the Marwood owners. Okay, basically.
And it was changed in what sense?
So it was changed in the sense, Your Honor, I would have received additional funding, but because the property management company failed to bring the building up to code with regard to repairs, I was prevented or procedurally barred from receiving additional funding. Rather than for him to be candid with me about that, he didn't. He just basically.
Let me cut you off. Is that the 20% of the 100% that wasn't received? Or is it 100% of a whole different load of funding? Because when houses aren't up to code, 80% is granted and 20% is retained in escrow. Is that the case? Is this the case with this property where 20% was retained?
No, Your Honor.
It's not the case, Your Honor, because for somehow I slipped between the cracks. It is actually technically, but they ended up pushing it through anyway. But they pushed it through because I'm for sure, if I were a betting man, I'd bet my kidneys in Vegas that the property management communicated with Sarah and somehow where they was going to approve the additional funding, which they would have all of their money at that point, they couldn't because the building was not up to code with regard to repairs. But then, Your Honor, there's another issue.
Are you saying, let's stay with this issue first. Are you saying that that the building refused money or refused funding?
Not only did they refuse additional funding, the funding that I had gotten, they changed it. And I have the documentation from Sarah to support that statement. They came back.
This is the issue when it comes to this case. At the time you signed your lease agreement, Sarah was not obligated to pay any of your rent. At no time is Sarah obligated to pay your rent. This is rental assistance and something that is provided at a gratuitous basis, on a need basis, but it is not, none of us are entitled to it. So the reason why we're here is for non-payment of rent. And I'll continue to let you address your second issue, but as it relates to Sarah, this is an add-on. These are extra toppings, and you still have to have the burger and the bun.
Yeah, but you have to qualify to have the burger and the bun, and I qualified. I was disqualified because not through any fault of my own. I was disqualified because the building that I happened to reside in didn't do their part. They weren't up to code with regard to repairs. So when we say that it's not an entitlement, it's gratuitous, okay, I'll give you that. But I would have had that money. It would have come to me. Therefore, the bill would balance of the account for the Marwood would have been paid if they had done their part. They didn't do their part.
All right, how much rent is owed?
So there's a balance. So I have $9,346, which I never articulated or stated to them that I wasn't going to pay them. I think in the breakout room, Attorney Sprague stated that that somehow, I think it was something to the effect, she stated that I didn't make any effort to get them their money. Yes, I did. And I have documentation of that. The issue is, again, I have the money and there was repair issues where the rent needs to be abated. In fact, they know about it. They're aware that there was the building flooded, Your Honor, and you can send an agent to the court from the court to come out to verify it. The entire first floor of this building is flooded out. There are several floors in the building that are flooded out. Mine was flooded out, causing my entire bedroom to be flooded. Then there was an issue with the hot water. The boiler has been an issue on and off for years. So this action didn't come until they repaired the boiler, right? But we've been without hot water over here for a long time, very long time. And my entire bedroom has been flooded out. Now I have a thread of emails with the property management company going back and forth about this, trying to figure out when are they going to repair the apartment, the entire bedroom, so that it's livable, so that I can move on with my life here. And there's been no conversation from the property management company. Keep in mind, now also I want to state that they have not been communicating with the property owners as well. So for the property owners to come back and say, okay, this guy's been there all this time and he owes rent. Okay, well, I'll give you that, Your Honor. They're correct. And I didn't have any problem with paying it. And by the way, I was sick, which is one of the reasons, and caught COVID, but I was also sick on top of that, which caused me to have to get the SARA funding. And when I entered into the application to get the SARA funding, like I said, there's been an issue back and forth with them, and it come to find out it's all because this property is not up to code with regard to repairs. So where I'm at today, we need to first get this bedroom addressed, get the repair work done. The entire bedroom is flooded out, and we need to abate the rent. If they're saying that I'm on the hook for the entire $13,000, okay, I would agree with that in a perfect world, Your Honor. But in the case where we know that these other things are involved or in place, shall we say, I think the cutoff should be $9,346 based on what has happened.
And what's the $9,346? What's that math?
And that math would come into play because that would have been where Sarah had come back and says, okay, we're going to change your awarded amount. And they sent out a letter with a new award amount. So again, I would have gotten additional funding beyond the $9,346. But again, I can't control what the property company does with regard to making repairs to be eligible to be in the program. But I think in all fairness, they should be communicating with the tenants and letting them know that, listen, this is what's going on. This is what has happened. We're not up to code. And as a result, you are at jeopardy for receiving your entire SARA funding. They put me in this adverse negative light. They should be the ones that eat the cost with regard to the balance, the remaining balance that I would have otherwise received from Sarah.
All right. So
Your Honor, may I reply?
absolutely.
I'm going to start at the beginning of the defendant's allegation that the property manager somehow managed to change the amount that Sarah provided. As was relayed to the defendant as well as defendant's counsel, Sarah only pays through September of 2022. And so if you look at that 9346 amount, that reflects the exact amount that the ledger would have been as of September 31st of 2023, or I'm sorry, 2022. Therefore, his allegations that our property manager somehow managed to diminish his award or that it was diminished due to repairs of the property is completely unfounded, unreasonable. And as this honorable court knows, Sarah only pays up through September. Therefore, October, November, December, January, February, March, April, and May's rent would still be due. Additionally, the defendant has only made one payment in October of 2022 since June of 2021. I have not heard that he has placed any funds in an escrow. My client has not been notified of any escrowed funds, which would be appropriate in an abatement of rent case. Therefore, that argument again lacks founding there. Regarding the allegations regarding the repair issues with the leak, there was a leak on Christmas Day. However, that was timely repaired. Additionally, the water boiler was installed about a month ago, and they are in the process of doing an insurance claim for the remaining flooding issues, which, as your honor is aware, does unfortunately take some time to repair. During that time, though, I'm not hearing anything that would necessitate an abatement of rent. It's my belief that this is a stalling technique on the part of the defendant. The defendant received over $9,000 from Sarah and refused to make payments for his rent or refused to place it within an escrow account, which would have been appropriate. So for that reason, I am asking for a judgment. I do have the regional manager here today that would be able to substantiate those claims if you require his testimony as well.
Mr. Johnson, thank you, Mr. Gray. Mr. Johnson, you have $9,346 from Sarah funding that you haven't turned over to the landlord?
And your honor, I didn't turn it over to the landlord because the process, in order to do that, you got to have a conversation with the landlord. The property management company has been ignoring me. Okay, now
the conversation with you if you had $9,300, Mr. Johnson. I don't believe it.
Attorney Sabree, I can assure you,
Judge
document, I have the
Judge-
document. I can assure you I have the documentation to support them avoiding me, okay? And with respect to her statement, the Attorney Sprague's statement regarding the water leak in December, yeah, you had one in December, but you had one on other dates too.
Where's
Okay.
this 9346, Mr. Johnson? I'm gonna cut you off. Where's this 9346 stored? Are you earning interest off of this money?
Say again?
Are you earning interest off of this 9346 that you
Not at all.
have?
It's in my hand.
Well, you need to turn it over to the landlord. Okay?
I have no problem, Your Honor, I have no problems with that. When I
You have
ultimately tried,
with it because you've had it for almost a year now.
but you understand, no, I haven't had it almost a year. I just got it. And as a matter of fact, I wasn't supposed to get it. It should have gone to the property management, and it
All right,
didn't.
so with this, like, what is the solution? How much is owed? It's 13,000 owed. How much, Attorney Sprague, is the total amount?
Yes,
Your
there
Honor.
is currently due and owing $13,731. We would seek a judgment for possession of 10 days. There is no money order, or I'm sorry, there's no money judgment requested with this case. We are seeking possession for a pay or vacate date of 10
Your Honor.
days.
Your Honor, this is not a stalling tactic on my part, first of all. Secondly,
I don't care about it being a stalling tactic or not. I just want to get to a solution. I want to get to
okay,
a
but we
resolution.
can't get to a solution, Your Honor, until we sit down.
Yes,
and
we
really-
can get to a solution right now. I can say, hearing by judgment, you pay X amount, and we're done. I just want to make sure it's a fair solution.
But it's not a fair solution, Your Honor, because so far, okay, she's actually denying what's going on with regard to the repairs there at this property.
Since 8:30 this morning.
Please mute your device. I understand. Somebody ends up being last, and I'm sorry it's you today, Mr. Combs.
Okay, but also September. She states that the payment goes from September. She's correct in saying so, but everybody, Attorney Sprague knows as well as I do, Sarah will extend funding beyond that if you have extraordinary
Sarah
circumstances.
is over. Sarah, stop talking about Sarah as if you're supposed to receive it. They give it to whoever receives it. The money ran out, so nobody can get Sarah. Sarah was never going to pay your rent until Sarah paid your rent, if that makes any sense. You can't rely on something and then blame your non-payment on the fact that a funding agency decided not to give you money.
No, Your Honor, that's not what I'm saying. That's not what happened. Basically, Your Honor.
You say Sarah, as if Sarah is obligated to pay your rental amount. So if they want their rent, I'm pretty sure they didn't. Okay, you're saying the building was up to par, they would have received more. Well, it wasn't up to par. So I haven't heard anything about rental abatements. The water heater was fixed last month.
That's what an attorney is for. I need an attorney.
You requested an attorney, you had another attorney. Mr. Martinez is in here every single day.
Okay, well, wait a second. I don't think the responsibility or the onus should be on me at this point, Your Honor. If I had an attorney on May 2nd, and that attorney, for whatever reason.
Attorney. How much did you pay for that attorney? How much are you out of pocket? How much are you out of
Zero,
pocket?
but did the attorney hasn't represented me.
Right, but then somebody else represented you today, Mr. Johnson.
Okay, and he's not fully in command of all the necessary knowledge to get through this case at this point, which is why I asked for an adjournment.
Which is why you're going to represent yourself. And he's still here and advising you on an advice-only capacity. This is a summary proceedings hearing. This originated, if this were before COVID, it would be no Sarah, and this would be a one hearing situation. Now you have two hearings with 2 weeks in between the first hearing and the second hearing, where you're afforded an attorney. If not an attorney, you're afforded time to find counsel. And
well, wait a second.
and saying that you need an attorney.
Well, it's
Okay.
not my fault, Your Honor. The attorney notified
Yeah.
at the final hour yesterday.
I think you have to take responsibility for this one, Mr. Johnson.
Your Honor, it's not my fault. The attorney notified me at the final hour yesterday to tell me that you can't handle the case.
But it's your situation, and it's your situation. So I can't speak for legal aid, and maybe they couldn't. Maybe they didn't find a tribal issue of fact that they could represent you on. And
That
said,
was not
well,
stated in the notice. What was stated in the notice was only.
it's not. I don't care what's stated in the notice, because Mr. Martinez is here today, and he tried to represent you. But I'm assuming that he didn't see any tribal issues of fact.
That's because he doesn't have all of the information.
We have tons of information from you today.
Your Honor, I'm asking for an adjournment because there's other information involved with this case that I need to get to the attorney.
What information?
There's information regarding repair work to rebut what Ms. Sprague is stating. She stated that the water damage started December. Yes, she's right about December, but there was other water damages after that. I'm also asking that.
Stop speaking over me. Stop speaking over me. What other water damages? What other water damages exist? Stop speaking over me. We're on Zoom, man. I can mute you if I need to. Just stop speaking over me. It's just.
I apologize, Your Honor.
We're gonna get to the bottom of this, Mr. Johnson. What other damages?
Water damage to the entire bedroom that happened after December, after the day of Christmas. There's continual water damage.
How much did it cost you? What's the continuing water damage? I mean, it's like.
What it cost me is the apartment has not been livable.
All right, so so are you living in the property right now?
No.
Okay. Have you vacated the property?
No, I have not. And when you say live in the apartment, right now, I live in the apartment, but not in the bedroom. It's a 1-bedroom apartment, Your Honor. And I think we should probably get a court officer out here to really come out here to verify my story. Because these people are.
Are you at your apartment right now? Why don't you cut your camera on?
Say again?
You're at your apartment right now, aren't you?
Yes.
Or you can cut your camera on. Show us what you're talking about.
You can't see the water damage to the floor, Your Honor, while I'm here on Zoom. You're going to need to have somebody come out here. I actually requested an appointment for BC to come out.
All right.
This is why I asked for an adjournment.
How long do you need, Mr. Johnson? Because I'm,
Say again?
I'm ready to end it today. How much time do you need to vacate?
Say again, Your Honor.
How much time do you need to vacate or pay the $13,731 that you've approved in rent?
Okay, Your Honor. I'm asking for an adjournment so that the attorney and I can discuss this further regarding my damages.
You don't have an attorney.
Well, I didn't know that until today.
Your Honor,
yesterday.
Your Honor, if I may, Mr. Johnson is bringing up these repair issues. How about any order of the court? Just we enter that the plaintiff will inspect and repair any repair issues that Mr. Johnson may have.
All right. And Mr. Johnson, do you have a claim with the insurance? Is he involved with the insurance claim, Ms. Sprague?
I do not know, Your Honor. Oh, I'm sorry. No, he is not.
Okay, you have a representative from the building, Ms. Sprague. Is that what you said?
I do. Mr. Robinson is on.
All right, Mr. Robinson, I'm sorry about that. Can you state your name for the record?
Hi, my name is Justin Robinson.
Thank you, Mr. Robinson. And do you swear to tell the truth and nothing but the truth?
I do.
All right. And do you work at the property, or are you familiar with the property 53 East Marston?
Yes, I am, Judge.
Is that an apartment building?
It is, yes.
All right. And then what's your role? What's your relationship with that property?
I'm the regional property manager for a management company. We represent the owner to operate the building.
Okay. Are you familiar with the conditions of Unit 208?
I've been in there before, but not recently.
Okay. And are there any pending repair issues that have not been addressed?
I was not aware of any. I know there had been a water issue in the past in 208, but I thought we had that taken care of for Mr. Johnson. So I understand that everything is fine in 208.
Mr. Robinson, would you be willing to do a maintenance check and repair any issues?
Yeah.
Thank you.
Your Honor, real quick, if I may.
Sure.
Okay, on August 10th, 2022 at 1:02 p.m., I received an email from Justin Robinson. Here's what it states. It states there was a leak above your unit. We are entering your unit to confirm that there is no damage to your unit as well. I wanted you to be sure you are aware. Now that's August 10th, 2022. So on the day that he went into that apartment, now keep in mind, Your Honor, this is after the December 25th Christmas date that Attorney Sprague stated that there was a water leak. Okay, again, this is August 10th, 2022. Mr. Robinson entered the apartment. So undoubtedly, if Mr. Robinson entered the apartment on that day, Your Honor, he knew in fact that there was water damage. And since then, he has not returned to repair it, nor has he made himself available to have a discussion with me about that, among other things. As a matter of fact, I even went above his head and called the property owners to tell them what had happened, and they were shocked that he did that. So when he said—
So what happened when you called the owners? What happened when you called the property owner? Did he come out and fix it after that?
So he said that, listen, I'm going to copy him on the email, but then I get a call from Mr. Robinson. Now, Mr. Robinson knows that I do everything, I reduce everything to write in emails so that we're all clear on the same page. At that point, he switches up the communication, Your Honor, by wanting to speak with me verbally. So he did come out to talk to me verbally, but guess what, Your Honor? He took no action with regard to making amends or fixing the repair work or addressing the flooded bedroom. And watch this, Your Honor, this is important to note. During the time that the water leak took place and they sent someone in to address the water leak, they sent someone else in from property management who went in the apartment multiple times and stole from me. I have the camera footage. I have the camera footage of them going into the apartment unlawfully during the theft of when this happened. So this is why I say there are a lot of issues with this case.
Okay, all right. And what floor are you on?
Second.
How's the second floor flood?
Great question.
Has the second floor ever flooded?
Your Honor, every floor on this building has flooded, and if you come out, you will verify what I'm saying.
Your Honor, if I may.
Resolution about 5 minutes.
Your Honor, if I could make a couple comments. Sure. On Christmas Day, the 25th, I think it was a Sunday, it was pretty cold and we had a burst pipe on the first floor. So I do recognize that there's been an insurance claim and that we are repairing a few units on the first floor and potentially one unit on the second floor, which is on the exact opposite side of apartment 208. That has not affected apartment 208 at all. I also do recognize that apartment 208, I believe there is a common area air conditioner above 208. And last August, being before the Christmas event, that there may have been, I believe, like a condensation pump that was not running properly and that some water may have leaked down into apartment 208. I would tell you, this, that apartment 208 does not have some type of continuing leak. That there's any major issue. Has there been a leak in the past? Yes, there was a leak in the past. And I would be willing to get anything fixed ahead of time. Or excuse me, not ahead of time, but anything fixed moving forward.
All right, thank you.
Your Honor, it's odd that he'd state that there's no continuing leak. He's correct in stating that. But the entire bedroom is already flooded and damaged and molded. He has not stated anything with regard to that.
Can we see, you're there now, are we allowed to see the damage?
Here, well, Justin, let's be straight with each other. When you came in,
Mr. Johnson, he asked a question. You wouldn't put your camera up. You had your camera up the entire day.
Okay, hang on a second. Your Honor, the camera is up. Here, first of all, again, you're not going to be able to see us over Zoom. You're going to need to send someone out.
You don't know what we can see. We asked to try to see, to try to address your issues, but there's no willingness on your end. So I'm going to enter a judgment by hearing.
Here, you want to see the floor, Your Honor? It's not going to be.
We've asked to see the floor.
Hang on a second. Okay. I don't know how great you're going to be able to see it because it's just not, you can't do it over Zoom, but here it is. The entire floor was flooded out, Your Honor. He walked in the water, very high water when he came into their bedroom when he came to check the leak. So he has not stated anything since then. So he knew that there was an issue then. Why is he willing to fix it now? Why couldn't he fix it then?
All right, so all right. The court is going to enter a judgment by hearing.
You said you can't see it. I'm pointing the camera right there at it, Your Honor, the floor.
The camera's not even on.
Okay, hang on a second. The camera's supposed to be on. I didn't turn it off. Hang on. I think you told me the bandwidth earlier in this case was affected.
Yes. So I cut your camera off.
It's not my fault, Your Honor.
Okay, nothing's your fault. And this judgment is going to be my fault. It's a judgment by hearing. Did you have any damage to your unit?
Yes.
How much would you say was damaged? What was damaged?
Electronics, clothes, what have you. Bed.
Your bed on a frame?
Not at the time.
All right, the court's going to enter a judgment for hearing.
Your Honor. Your Honor.
$12,000. I'm going to give you a credit of $1,731. $1,731 will account for all your damages, for your non-itemized damages, and that must be paid by May 31st, 2023, or a writ may issue. That is the final judgment of the court. Thank you.
So, Your Honor, did you rule on my adjournment?
You're not getting, I denied your request for an adjournment and entered a judgment for $12,000 that needs to be paid by May 31st, 2023.
What recourse do I have, Your Honor, to appeal?
I can't tell you that. Your You can appeal, you have appeal rights, but you need to.
So would I need to go through this attorney here at Lakeshore to do that?
I don't know what attorney, he said he was willing to only give you advice only. So he hasn't retained you, you haven't retained him as a
So wait a
client.
second. How do we go from having a right to counsel, getting a lawyer, to him saying he was going to give advice only? I thought
Because as a lawyer with a P number, they're not required to represent you. They don't have an obligation to represent you to the extent that they just must do what you asked them to do. They're not required to. They have to make a decision based on your request. And the decision was that he'll give you advice only. The only way you can obligate someone truly is with an agreement and some consideration. So if you want to put some money in an attorney's hand to obligate them to represent you, that will obligate them. I'm not saying that they're not obligated, but once they sign that retainer agreement, then they're obligated. And I'm pretty sure he didn't sign a retainer agreement, especially if they sent you a letter and were so thorough about getting back to you saying that they wouldn't represent you. So you just have to find someone to appeal the case, or you can appeal it yourself, but that is the final judgment of the court, and I can't give you legal advice.
Well, what if I need more time than the 31st?
And you'll be in the same situation as everyone else who's coming in front of this courtroom who may need more time.
I don't understand. I'm asking for more time than the 31st.
Okay, and I'm by court rule allowed to give you 10 days. I went beyond the plaintiff's attorney's request for 10 days and actually gave you until the end of the month.
Yeah, but wouldn't that, Your Honor, I'm not trying to give you a hard time, but understand, this was a process that took place where I didn't even have a lawyer. So.
All right, okay, I understand. And you had, it sounds like, okay. All right. Okay, well, if you find a lawyer, they can file the appropriate pleading and set this aside. Okay?
Okay.
All right. Love Mr. Johnson. On case number. Are you ready on Belcher?
We are.
Are you ready like this one, or?
I hope it's not like this one, Your Honor.
It won't be.
I hope so too.
Hopefully we have a little more like, I don't know, remorse.
Calling case number 23346625. This is Marwood Marston 2020 Limited Divided versus Michael Belcher and all occupants.
Attorney Samantha Sprague, P 81931, appearing on behalf of the plaintiff.
Thank you. Michael Belcher.
Yep. Hello.
Hello. Can you state your name for the record?
Michael Belcher.
All right. Thank you. All right. Okay. So parties were not able to work out an agreement. Is that true?
No, Your Honor, we do currently show that there is due and owing past due rent in the amount of $8,888, other costs of $225, and court costs of $160 for a total due and owing of $9,273.
Okay. Do you agree with the amount owed, Ms. Belcher? Mr. Belcher?
Yeah, I agree.
Okay. All right. And how much time, counsel, are you allowing for this amount to be paid?
Your Honor, I'm only authorized to provide 10 days at this time.
But I'm gonna need more than 10 days. I work a federal job and I work 7 days out the week. I'm gonna need more than 10 days. I need to take time off to get the stuff.
If I may, Ms. Belcher, you'd indicated that you were unemployed currently and therefore unable to provide any.
No, I told you I'm employed, but I said I'm on restrictions because I'm going through a civil suit because I got into a car crash. You wouldn't let me finish because you wanted me to hurry up and get off the phone. You just said 10 days, and you said, okay, leave the break room. You didn't let me finish what I had to say.
You indicated you couldn't provide any sort of payment whatsoever, Ms. Belcher. So that's why we're here today for the judge to make a ruling.
That's not the argument. The argument is you said that I said that I didn't have a job. I didn't say that.
All right, so
Here we go. Your Honor, I'm not hearing a legal defense to non-payment of rent.
Ms. Belcher, when can this $9,273 be paid?
You said when can it be paid?
Yes.
Let's see. Well, I could do it. She never discussed the payment plan or anything. Like, this is my first apartment, so I'm trying to figure out, can I do a payment plan? But it's like, she tells me that's not an option.
She's the attorney for the landlord. So if you were to approach the landlord and that got worked out in writing, then Ms. Sprague is out of the picture. But right now, there is no payment plan, and legal action was filed for non-payment of rent to recover the amounts of rent that's owed. And this is the proper way of going about that. And she's only obligated by court laws to allow 10 days. So you all can negotiate more, but that's part of you and counsel's negotiations. So how much time do you need to pay the $9,273?
I'm gonna need 2 months.
You're not gonna get 2 months.
Right, but you're asking me a question. I'm just being logical. I can't say 10 days. I'm not gonna have $9,000 in 10 days.
Your Honor, there's been no payments made on this account since August of 2022.
Have you paid any rent since August 2022?
No, I haven't.
All right, so there should be some funds to either pay or vacate. You can
No,
vacate.
I'm going to vacate. Yeah, I'm going to vacate, but I'm going to need more time to vacate. I have to get a storage unit so I can put my stuff in. 10 days won't be enough. I work a federal job, 7
Your
days
Honor,
out the week. I have to take time off of work.
Go ahead, Counsel.
We can agree to 5/31, and we can agree to the end of the month. That way, she's not incurring an additional month's worth of rent.
Okay. 5/31 is better than 5/20. I'm going to put it to June 2nd, Counsel. I know you're concerned about incurring additional rent, but she's already at 92.73, and I know you're not going to get it rented out by June 1st. And I know that's beyond your realm, your 10 days anyway, and you've already extended it to the 31st. But June 2nd, 2023, you must pay $9,273 or vacate by June 2nd, 2023, or a writ of eviction could issue.
Okay, thank you.
You're welcome.
Thank you, Your Honor. Have a good afternoon.
You too. Good luck.
Your Honor. Your Honor.
Yes.
The Cone case.
Calling case number 2334-6563.
Yes.
Daryl Cone versus Danielle.
Danielle and Freddie and Danielle and Freddie.
Yes, I'm here.
All right. Okay. Thank you for your patience, Cone and Ms. Matthews. You are not the least, but this is the last case of the docket. Something falls.
I hope you're not upset about the other cases, Your Honor.
No. one by one. We're gonna take
Okay.
these one by one. And
Okay,
these are unrepresented. So let's state your names for the record, and I'll be the intermediary to try to help facilitate, help get it done. All
My
right.
name is Daryl Cone for the record.
All right, thank you, Mr. Cone.
I'm Tanika Cone.
Tanika Cone, thank you. And Ms. Matthews?
Danielle Matthews.
Danielle Matthews, good afternoon. And is there anyone else here?
Freddie Matthews.
All right, thank you, Mr. Freddie Matthews. Okay. Today is the date and time for a complaint to recover possession of property.
Yes.
This is different than the last cases because there was an amount to redeem. There's no amount to redeem. Is there any issue? Do you all contest the fact that the Cones own this property?
No.
Okay. All right, and do you indeed own this property, Mr. and Mrs. Cone?
Yes, sir.
Yes, we do.
Okay. All right, so how much time is needed? How much time is being requested? Did you all get close to an agreement? What's going on?
No, we didn't get close to agreement, Your Honor. They're like 3 going on 4 months behind, and I don't think we can come to agreement, Your Honor. I just want to get my property back.
That is not the situation, but Your Honor, like you said, this is the last case. I can be gone, Your Honor, on the 3rd or the 4th of June, if that is okay.
Of June, we're looking for May, Your Honor.
She's saying 3rd or 4th.
It's been 4 months.
That is not
true. I just gave the last person June 2nd, so I'll give her June 2nd. If you're saying May, that's 2 days earlier. May 26th is if you're not giving her anything, she's gonna get until May 30th anyway. 26th is a Friday. You got Saturday, Sunday, and Memorial Day, which put you at May 30th. So with you not giving her a single extra day, she's gonna get to May 30th anyway.
Okay, Your Honor.
Just immediate tendency termination. That's all.
All right, so June 2nd will get you to June 5th, Ms. Matthews.
Okay, so on June 5th, I will, okay, quick question. You said June 2nd to get me to June 5th. My only question was, where do they want me to return their keys and the garage thing? They can come get the garage thing beforehand because I don't have anything in there. And
you have a chest in there.
Okay, I can move that out. I was just trying to, you know what? I can just see, I'll just make sure I give it to him on the 5th then. Fine.
Okay.
Your Honor, can we have the earlier date that would just give them to the end of May?
I'm gonna give her June 2nd like I got the person before her. That's a Friday. That'll give her the weekend to move her things out, and you can file for a writ on Monday.
On that Monday?
Yeah, you can file for a writ of eviction June 5th.
Okay, Your Honor.
On paper, the move to be June 2nd. So you all wouldn't be able to go over there on the weekend and say anything or do anything until the writ came in on June 5th. So it's not too much from what you would have got. It's an extra week.
Okay, Your Honor.
All right, so this is a judgment by hearing where, is there an objection to a removal of all of a named party?
No.
We want all occupants. Yeah.
Okay. Okay. So we're going to remove Ms. Matthews' name as a named party and enter judgment as all occupants, where all occupants must vacate by June 2nd, 2023, or writ of eviction can be filed.
Thank you so much.
To the cones, if you submit your judgment to the court, we can sign it in person. If you want to fax it over, but it's up to you. Ms. Matthews, there's a possibility that someone could be knocking on the door probably midweek on that. But an application for a writ of eviction can be signed June 5th. So I just want to let you know. June 5th, after that date, it could be June 7th, it could be June 10th, but legally they'll be able to apply for June 5th and following days. So good luck, Ms. Matthews. Good luck to the cones. Thank you all for your patience, and you all have a great day.
You as well.
You as well. Thank you.
Do I just hang up now, Judge?
You can sign off. You can sign off.
Okay, thank you.
You're welcome.
Have a good day, Your Honor. I think we're all done.
Right. You too.
Thanks, Your Honor.
All right, so June 5th, we're back in person, first hearings and second hearings.
Judge, we still live if you want to go off live or you want that.
Okay.